Good morning, everybody. Happy Thursday. Welcome to TCF Live. My name is Dan Soul. I will guide you on this 3-hour tour of Courtlandia. Start in Allegan County, Michigan. This is Judge Skocelas.
For sentencing at your arraignment on May 13th of this year, you entered a plea of guilty to a charge of operating while intoxicated while having a high blood alcohol content. As required at that time, I set this for sentencing and ordered that a pre-sentence investigation be completed. That has been completed, so we are able to proceed to sentencing today. First of all, Mr. Channels, I'm required to advise you at every step of the proceedings, you do have the right to the assistance of an attorney. If you cannot afford one, you can request one at public expense. The public defender's office indicated at the time of your arraignment on May 13th that you did not wish to have a public defender and that you wish to plead guilty at your arraignment, and you did so. Just a reminder that you do have the right to the assistance of an attorney, even just for purposes of sentencing. So first of all, sir, do you wish to proceed today on your own, or do you wish to request a public defender for purposes of your sentencing?
Just ready to proceed.
Okay. And I have received the materials that I received from the probation department, so we are able to proceed to sentencing. Is there anything else you would like to tell me for your sentencing, Mr. Channels?
No, sir.
Reviewing those materials, I do not see any prior drinking and driving offenses, which is good. Your blood alcohol level, though, is nearly 3 times the legal limit at a 0.224. Which is my concern. And obviously with the blood alcohol content that high, we are going to try and do something to make sure that this doesn't happen again. So what I'm going to do based on your blood alcohol level alone is to place you on probation for a period of 6 months. And that's going to be with substance abuse counseling as directed by the probation department. Standard condition of probation on this charge is do not possess or consume any alcohol, marijuana, or illegal controlled substances other than those prescribed to you by a medical professional. They will have the authority to check you for alcohol consumption here at our probation department, have you checked by the police at your home in Plainwell. And for the first 30 days of your probationary period, because of your extremely high blood alcohol level, I am going to order physical monitoring for alcohol consumption utilizing either the SCRAM or SoberLink methods at the discretion of the probation department. And your probation officer will explain in just a moment which of those it will be and what that's going to consist of. On this charge, they'll also require completion of a victim impact panel. Because of this charge, sir, your driver's license is going to be suspended for the next year, and that's probably already happened after your plea. Is that true?
Yeah.
Okay.
Yep.
Okay. So a specific condition of your probation is that you not operate a motor vehicle until you obtain a license to do so from the Secretary of State's office, which means getting caught driving for any reason is a violation of your probation and could result in a jail sentence. So just keep that in mind. If you get any temptations to make a quick trip to the store, that little bit of driving could result in a jail sentence. It also could result in a longer suspension period from the Secretary of State. And on this charge, the fine is $500. Court costs are $400. State costs and fees are $125. There is a $180 oversight fee for that term of probation and a $100 fee for the substance abuse assessment that was done through the court for a total of $1,305. Court file shows that you were released from the Allegan County Jail on a $500 personal recognizance bond, so all of that is due. You will have the entire time on probation to pay that amount on a monthly payment plan set up through the probation department. Our probation department is going to contact you on the telephone to set up your probation order this morning. What telephone number can they reach you at today?
The one on file, it's 269.
And you don't have an attorney, so you just have to listen carefully here. Normally, on a drinking and driving offense, you'd be eligible to be discharged at the halfway point of your probationary term. Sir, I apologize. My note is incorrect. I have a note. You actually pled guilty to the charge of operating while intoxicated with a high blood alcohol content. That was not reduced by the prosecutor, correct?
No, it was not reduced.
Okay, all right.
No,
I apologize. Okay, let me do one thing here. Then I need to change something. And what made me think of that is we started talking about the probation here. So let's see. I realized my mistake. I gave you a bit of a break on the fine because the maximum fine would be $700. I kept it at the same as an operating while intoxicated at $500. What I was going to say, Mr. Channels, is this is a unique charge, operating while intoxicated with a high blood alcohol content. And my understanding of the law is that it has not changed. It used to be that you had to be on probation for a full year on that charge. So even if you did great on probation, your probation officer had no right to have you discharged early because of the nature of the offense. Since that time, Michigan law has changed again and allows certain people to get discharged at the halfway point of their probation if they complete probation successfully. I have not seen anything that affects this charge. So what I've always told the defense attorneys is that I believe, and no one has told me otherwise, that I think you still have to be on probation for the full year. Maybe your probation officer will know differently, but my understanding is, first of all, that I have to place you on probation for 12 months, and it will be on probation for 12 months. And I think part of that is because your license is also going to be suspended for that full period of 1 year, and the probation term is going to match that. So I do need to modify your order of probation. Instead of 6 months, it'll be for 12 months. And the oversight fee is increased up to that 12-month point for an additional $180 for a total of $1,485. But again, you will have the entire year to take care of those fines and costs on a payment plan set up through the probation department. So the bottom line is you have to be on probation for a full year because of the nature of the charge being operating while intoxicated with a high blood alcohol content. I'm going to send the file down to our probation office. They're going to contact you at the telephone number you just gave us. They will set up your probation order over the telephone today, so you won't have to come into Allegan and sign everything. Good luck to you, Mr. Channels. I hope this all works out successfully for you.
All right. Thank you.
Thank you.
Once again, everybody, good morning. TCF Live on a Thursday. Hope you all have had a good start to your day so far. Barbara celebrating 14 months as a channel member with $15 worth of super chats. Thank you so much, Barbara, for your generosity, and thank you for sticking with me for these past 14 months. I appreciate you. Let's go to St. Joseph County, Michigan, but not Judge Middleton. This is Judge Pattison holding court from the converted broom closet.
All right, this is file 26264, is People of the State of Michigan versus Edward Allen Colt. Mr. Colt is here with counsel, and Ms. Camfield is here on behalf of the people. Mr. Frazine's here from our probation department. On March 20th, 2026, Mr. Colt pled guilty to 1 count of impaired driving and 1 count of domestic violence. And so Mr. Frazine prepared the pre-sentence report, so we'll let him lead the way. Mr. Frazine, go ahead.
Thank you. This is a count of drunk driving as well as domestic violence. They stem from the same issue. Blood alcohol content was a 109. Mr. Colt was 72 years, was in Benton with his wife, Virginia. They have been married over, I think it was like 53 years. He is retired and collecting SSID. He does have a lawn care business and plows in the winter as a side job, or I guess you could call it. He also does have a pacemaker as a result of a quadruple bypass and some health issues, which also means that he has to take some medicine, which may contribute to a lot of this because a lot of those medicines, as we discussed, you're not supposed to be taking alcohol. Because Mr. Colt rarely drinks, he said he never really gave that much thought. If he does drink, he typically just has a margarita or a Long Island iced tea or two. On this particular date, back in February, he was doing some chores around the house. About noonish or so, decided to have a Long Island iced tea. He said it probably wasn't the best idea because he hadn't eaten and he hasn't taken his meds. Normally he takes his meds when he gets up in the morning. That's when he's supposed to do that, and he did not take that. Then he decided to go watch, I think it was the women's hockey game at Island Hills, meet up with some friends. He had a margarita there, and then he left. On his way home, he got stuck. He called his wife. Because of their side business, he'd been stuck many times, and she'd come out and pull him out. So she grabbed a truck, went out to pull him out. When she got there, she did not think that she could pull him out. She was not very happy with him because he'd been drinking, and she decided to give him a ride. He got in the truck. Actually, she told him to get in the back of the truck. He was banging on the window. They pulled over. He tried to grab the keys from her. She was afraid once he got home that he might try to drive, and that was her biggest worry. And she was also worried about him having a medical issue because the way he was acting was not acting right. And it was more than just, it wasn't like someone that was bomb drunk. He was just not in his right source, according to Mrs. Colt. And she is out there if you'd like to hear from her later. And they ended up arguing, and they wrestled for the keys, but it was muddy out, and they fell and they all got muddy. Well, she ended up calling her nephew. He came and got her. The police showed up, and she was not real happy with the officers because she didn't want him arrested. They said that her hands were tied. And to make matters a little bit worse, she told him that she would come back for the trucks. And when she did come back later on, both vehicles had been towed, and it cost them several $100s to get those out of impound. And obviously her husband was arrested for drunk driving. She said that she was never afraid of him. She was more worried about him having a medical issue. That was the big issue. She had actually buried the keys or lost the keys while they were, when they fell. And her daughter was worried about her because she had spoken to her father on the phone and never heard him like that. And because of a third party thing, Mrs. Colt, Virginia Colt, said that that's probably why things sounded a little bit worse because she wasn't actually there. They were calling her at her home. So that might have been why the police thought things were a little bit worse than what they were. As far as the drunk driving, the only thing he had before was a dog and license like in 91. So this is kind of, this is a presumption case for the drunk driving. He has been in therapies for several months. They've been addressing his anger management in there and discussing better ways to handle things, as well as just helping him process how to make better decisions going forward. When I read the statute, it says that he has to cover, typically it's an anger management or a domestic violence, but since he's been doing that in therapy, I obviously leave it up to the court. I suggested that he continue with the therapy until discharge, and I can converse with his therapist to make sure that it does cover what we do in anger management. Being that he's 72 years old, this is kind of an unusual situation. I think a lot of it had to do with his meds and an interaction with the alcohol. His wife said nothing like this had ever happened before, which is the same thing that he echoed. They both love the heck out of each other. It's really an unfortunate situation. Obviously, the not drinking could have resolved all this. I definitely think at 72 years old, he's learned his lessons. And unlike a lot of my 20-somethings, this isn't going to happen again. And I think that we can pretty much, with a short-term probation, ensure that both he and the public are considered safe going forward. So I just recommended the 2 days jail, credit 2 days, 12-month probation, a spousal abuse deferral, random alcohol drug testing, VIP, alcohol highway safety course, and to continue with treatment until successfully discharged.
Thank you. Ms. Camfield?
I had an opportunity to review the PSI that was prepared. I disagree that this, but for the domestic violence, would have been a presumptive fines and costs. There was an accident and the vehicle was off the road, stuck in the ditch. The defendant admitted to the police officers that he had a couple of beers, but in his PSI, he told Mr. Frazine that on an empty stomach, he had a Long Island iced tea and a margarita within about 2 hours of each other, and then left the hockey game viewing party and drove home, not feeling the best. He said he was feeling off. He acknowledged he's not supposed to drink on his medications. I'm thankful that this presumably hasn't occurred before. And then we have a little bit of differentiation here in what Mrs. Colt told Mr. Frazine about the incident. Even trying to grab her arm and grab the keys, that was the admission at the time of the plea. That's still forceful, that's still, unwanted. And I think that Mr. Colt agreed with that when he pled under that factual basis. But the daughter is the one that spoke with the troopers and said, my mom called me and said he was stuck in a ditch and was acting like an animal. So those weren't the words of Mrs. Colt. Those were her daughter relaying what mom had told her. So in this situation, I think everybody can agree he hadn't done this before. They've been married 54 years without that type of a situation, which is good, but it shouldn't have occurred this day either. And I think everyone agrees that he's been remorseful, as he's indicated to this court previously and to Mr. Frazine. I believe when I spoke with Mr. Molderman previously, the thought process was that he would engage in the domestic violence treatment. My hope was that it would be through what we call Healthy Relationships LLC, which is with Julie Roberts in the Marshall area. And I believe she also does that online. So I'm hopeful that's what he engaged in. But as long as it's something extremely similar to that, I'm fine with Mr. Frazine's recommendation. If it does not cover what the typical deferral would cover, which is supposed to be a Duluth model domestic violence treatment, then I would ask that that be an additional responsibility. But if it is already covering those aspects, I'm fine with him continuing. I certainly prefer that somebody continue the therapeutic process they're already engaged in. Given his age and the fact that there is no criminal record, I'm fine with the 2 days, credit 2 days, and no additional jail. However, some deferred jail for probation compliance might be appropriate. Thank you.
All right, thanks, Ms. Camfield. Counsel?
Yes, Your Honor. First things first, we do want to make sure that we correct the report as to be accurate as to the plea. He pleaded to impaired and he pleaded to domestic violence under section 769.4A, not under 750.812. I just wanted to make sure that that was clear to the record. But Your Honor, this was an instance where it was the perfect storm. As has been mentioned before, Mr. Colt has a pacemaker. He had a triple bypass. He hadn't taken his meds that day. He had a few drinks, and things escalated to a level that they had never done before. In this instance, Mr. Colt has done everything to prove that he is remorseful and to show that this will not happen again. He has been seeing a therapist, Mr. Ryan Scott, out in Schoolcraft repeatedly. He, despite not having a prior history of alcohol abuse whatsoever, has been consistently going to AA meetings. He has been going out of his way to make sure that nothing like this ever occurs again, and to demonstrate that this was, in fact, simply a one-off experience, which I think is demonstrated by the fact that he's 72. We haven't had a record of anything like this before. Based off of the treatment that we've seen so far, I don't think anything like this is going to occur again. And frankly, when it comes to domestic violence, if you were to speak to Mrs. Colt is also in favor of a deferred agreement here. Obviously, the two of them love each other very much. They have been working through this together, and therefore we would recommend that sentencing fall in line with the pre-sentence report of the 2 days served and 12 months probation.
All right, thank you. Mr. Colt, you don't have to say anything, but you can if you want to.
Well, yeah, I apologize to the court and my wife and family circle. I wish I had a chance to change that day, but I don't. Clearly made the choice to drink that day and then drive. Know that that's a mistake.
All right, thank you.
No, I just wanted to add for the record that the preliminary breath test was a 0.13, so a little bit higher than the actual test came back.
The what now?
The preliminary breath test was a 0.13,
Okay.
so I think at the scene it was a little bit.
If somebody makes it to 72 without a prior drunk driving conviction, there's a pretty decent chance that it's because you, at least for the majority of your life, didn't have any kind of drinking problem. Most of the people who do, statistically, they drive a ton without ever getting caught. But if you have an alcohol problem and you're driving for 50 years, chances are you're getting caught. So at least there's some evidence to suggest that it's probably true that this isn't like your daily living isn't characterized by this. We're not seeing things here that we generally see. It's still just as illegal, but it's just not as concerning.
Judge Pattison, why do you do that sort of thing to us? Why do you kill a feed before the ultimate verdict is given? Good morning once again, everybody. TCF Live on a now slightly sad Thursday, but we'll bring it back. And let's bring it back right now because we were talking, or he was talking, about Long Island iced teas. And it's like, you know, every alcohol thrown together, topped with lemon and cola, basically. But anytime I hear it, it always reminds me of the Forget Me shot from The Simpsons. And the idea of the Forget Me shot is that it wipes the last 24 hours of the memory from the drinker's mind. And here is how Mo from Mo's Tavern prepared it. Jägermeister Slow Gin, Triple Sec, Quadruple Sec, Gunk from a Dog's Eye, Absolute Pickle, the Red Stripe from Aquafresh Toothpaste, and the Venom of the Louisiana Lobotomoth. To finish it, it would be stirred with a pregnancy test until the pregnancy test showed positive. The Forget Me shot. At some point in life, we probably all need that. Okay. Stay in Michigan, Judge Elmore.
28th Circuit Court here in Wexford County. We begin this docket day by taking up the case of People of the State of Michigan versus William Mankey. The case number here is 25-14058-FH. Joining me here in the courtroom today is Mr. Kevin Stapleton. He is the agent with the Department of Corrections, serving as the probation officer on this file. And also joining me via Zoom today is the defendant, Mr. William Forrest Mankey, appearing from the Wexford County Jail. Mr. Mankey, are you able to see and hear the court, sir?
Yes.
Mr. Mankey, we're here today for an arraignment on a request and warrant for a probation violation. That was issued by this court on May 21st. Count 1 alleges a violation of condition 4.18. That requires that you must not engage in any assaultive, abusive, threatening, or intimidating behavior. And more specifically, that on or about April 28th of 2026, you allegedly engaged in assaultive behavior by punching an individual named Nicholas Mercado Comer. Count 2 alleges a violation of condition 1. That requires that you are not to violate any criminal law of any unit of government. And again, more specifically, it's based upon the same allegation that on April 28th, you assaulted Nicholas Mercado Comer. And you have the right to challenge these two allegations at a contested hearing. That hearing would occur within 14 days from today's date. At that hearing, you'd have the right to have the prosecutor prove the allegations by a preponderance of the evidence. You also would have the right to have be able to question and cross-examine any witnesses against you, the right to have the court order any witnesses you may have for your defense, the right to be represented by an attorney at that hearing and all subsequent proceedings, as well as the right to present witnesses, evidence, or testimony if you chose to do so. Now, if you were to be found guilty at a probation violation hearing, you would be resentenced on your original offenses. Looks like you originally were convicted of unlawful use of a motor vehicle. Mr. Stapleton, I think that was of the 2-year variety, is that correct? Not the original 5-year, which is the unlawful driving away.
Yes, 2-year.
Thank you. Also looks like he's had some prior probation violations. Is that correct, Mr. Stapleton?
That is correct, yes.
Okay, and let's see here. Looks like there was a probation violation hearing held back in February on the 23rd. So anyways, there are what's called sliding scales for potential further jail on technical violations. Now, there is one technical violation here. However, it's also charged as a non-technical, which means the court is not limited to a sliding scale. That sliding scale is generally 15 days for one technical, 30 days for 2, 45 days for 3, or not limited if there's 4 or more. But again, the court is no longer limited to that sliding scale based upon one of these being a non-technical. Now, if you request to have, and we're going to talk about this in a moment, if you request to have an attorney or request to have a contested hearing, the court will set the matter, could be most likely next week, for a informal hearing. And it's at that informal hearing that you would appear before the court, along with Mr. Stapleton, along with the defense attorney, if you still request, and a prosecutor. At the informal hearing, that could become a formal hearing where witnesses and testimony are presented, or it could be set for a formal hearing. That formal hearing, again, is the one where there are witnesses, evidence, or testimony presented by the prosecutor and then potentially responded to by you and your counsel. Again, if you cannot afford to hire your own attorney, an attorney may be appointed to assist you. Now that I've talked to you about what the 2 counts are, what your rights are, and the possible consequences, I need to see how you wish to respond. Now, before I do that, I'm going to ask Mr. Stapleton a question. Do you know if he had any charges alleged in another case?
Yes, he does. Yes,
Okay.
he has assault charges.
And are those here in the district court?
Yes, they are.
All right. So, Mr. Mankey, if you request a counsel, most likely you'll get that same counsel if you request an attorney in the district court. So, do you wish to have the court appoint an attorney to assist you?
Yes, sir.
The court therefore will enter a not guilty plea on behalf of the defendant and will refer the matter to the Westford Misaki Public Defender Program for the appointment of an attorney. Moment. Do you know what your bond was set for, Mr. Mankey, in the district court?
Not enough.
Okay. Mr. Stapleton, do you know?
I do not. He's serving on another charge.
Oh, okay.
Until September.
Oh, all right. So was that another charge from the probation violations we had
Yes.
earlier?
Yes, it was a probation violation sentence.
All right, so it doesn't necessarily matter. You're still going to be, well, whether or not you get credit for it is something else we can talk later. The court's going to deny the defendant any bond at this time, refer him into the custody of the Washburn County Jail pending any further motion or modification of that condition. All right, so Mr. Mankey, you should hear from an attorney here soon, and we should be back here before the court. Most likely, I'm going to bet maybe Monday, but most likely Tuesday. Do you have any questions of me, Mr. Mankey?
Nope.
All right, thank you, sir, for your time and attention. We are adjourned.
TCF Live continues on this lovely Thursday. Let us go to that wonderful courtroom where the ladies often say that they show up for the justice, but they stay for the bailiff. Judge Simpson.
Waiver today. I was not able to say no.
You know, I almost, if I had not looked up, I would have said Mr. Cook, and then
Good morning, Your Honor. Maria Joseph.
it's gonna go. She didn't, but no, go ahead.
Morning, Your Honor. Maria Joseph for the people waive and he can say.
Between this honorable board and the public defender's office, the people do not believe such a conflict exists, but we make this waiver and we release all them.
Thank you. And you do it so much better than Mr. Cook. All right, thank you. Ms. Gaines.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender. We too do not believe that there is a conflict, but would waive any conflict if there is one.
Thank you, Ms. Court also, for its part, does not believe there's a conflict either under the Michigan court rules or the cases decided there under. To the extent a conflict does exist, given the waivers, court will consent to hear the matter. Court does call the case of the people versus, is it Choya Horton?
Yes, Your Honor.
All right.
Morning, Your Honor. An Assistant Public Defender Natalie Pate with and on behalf of Mr. Horton, who is present via Zoom from the MDOC.
Hey, welcome back.
Thank you.
Hi.
Hi, nice to see you.
Alan missed you. Go ahead.
I missed everyone here. Mr. Horton, could you please state your name for the court? Oh,
Troy
it looks
Dean
like
Horton.
Thank you,
Troy
sir.
Dean
Thank you,
Horton.
sir. Thank you, sir. Your Honor, I am requesting an adjournment for two reasons. One being I did discuss this with Ms. Dover. It doesn't look like either of us had the CCTV footage that's referenced in the police report. So she said she would check into getting that. And then secondarily, I have twice contacted the attorney visitor application system, and I've not yet been approved. So I'm still trying to get that squared away. So I'd ask for an adjournment like 4 to 5 weeks if possible.
4 to 5 weeks. Well, hearing no objection from the people, probable cause conference will be adjourned to July 16th.
Thank you, Your Honor. Thank you. And Mr. Horton, I'll be seeing you as soon as I can. All right. Thank
Yes,
you,
ma'am.
sir.
Thank you.
All right, thank you, sir. All right.
Thank you, Your Honor.
Court calls case of versus Tamika Schlipp.
Morning, Your Honor. Asked to Deltas for the people.
Schlipp?
Morning, Your Honor.
Wow.
Bright and early on your docket today.
No, go ahead.
Christina Costantino appearing with and on behalf of Tamika Schlipp, who is present via Zoom from the Michigan Department of Corrections. Tamika, once you're unmuted, can you state your name for the judge?
Hi, Mr. Simpson, it's me, Tamika Schlipp.
Hello, Miss Schlipp. How are you?
I'm doing okay. I got my parole, but it's on hold until I get done with this case. Then I'm going to Kansas psychiatric hospital.
Ah, okay.
Judge, on the bright side, I'm told.
Oh, it's having her back.
I'm told it's her birthday today on the bright side. So, you know.
Yeah, today's my birthday. I'm 36.
Oh, you can't be that old.
I'm 36.
30. Okay. All right.
I have a son. My son's 11 and my daughter's 10. I'm no girl.
Okay. All right.
Judge, I was just appointed to Ms. Schlipp's matter last night, so I need to get discovery and need to meet with her to discuss the matter. So we would be asking for an adjournment of the PCC.
We were going to ask for the 2 weeks, please, Your Honor, since I understand this may be holding up her parole.
This may be holding. Oh, you're right.
That's my understanding. Yes, Judge.
My parole's on hold until this case gets gone.
Got it.
I really want to go home.
Yes, ma'am. All right. June 25th.
When?
2026, 9 a.m. So we put it out to the 25th, Miss Schlipp.
Okay, at what time?
Well, I said it at 9 a.m. We'll see about that time, okay?
Okay, and Mr. Simpson, I just want to let you know I've been praying for you.
Thank you, Miss Schlipp. Appreciate it. Happy birthday.
Thank you to me.
Judge.
Court does call the case, people versus Devin, Julia Martinez.
Yes, Stephanie Cannon on behalf of.
Oh, you're back. I mean, hi.
Here, Your Honor, we're gonna waive our right to preliminary exam. I did not know they were not going to bring her. So the paperwork
right
as far
here.
as that. Yeah, Ms. Martinez, can I sign the waiver with your permission so we can waive over to circuit court?
Yes.
All right. And Ms. Martinez, you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Right.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Correct. I would like to also adjust my bond to being released to treatment, please.
Well, let's get the waiver done. People also waive their right.
Yes.
Preliminary examination having been waived, defendant is bound over to circuit court on count 1 in the case ending in 5840 and on counts 1 and 2 in the other matter with 3 and 4 problem.
Your Honor, as to bond, as my client has indicated, we are requesting that she be released on bond. I would ask for a very, very low monetary bond with a release to treatment. The reason for that is I do believe her circuit, the cases she already has in circuit court, Judge Mood has denied bond. So in order for her to get credit for this case while she's there, a low.
Denied bond and you want me to give her bond?
Your Honor, I'm going to try to give some mitigation information the next time we are up before Judge Mood so that we can get bond in that court as well.
That was also to address bond.
Yeah.
So
done with your argument or?
Well, Your Honor, I see the look on your face, but
Oh, what does that mean?
Ms. Martinez would like.
How I look? What does that mean?
It looks.
What? It's
the look of understanding that you.
Oh, okay.
Now, Ms. Martinez would like the court to know that the reason why she didn't wind up in treatment the last time is because when she got there, they said some information was incorrect, therefore she could not go, and they denied her access to treatment. She wants the court to know that that information will be corrected.
Which time was that?
The last time, Your Honor.
Happened a couple times.
I understand.
That
Your Honor.
has never happened before. That's never happened before. They denied me because it was some information.
She wants you to know that she does have a job. She has stable housing. She has a support system in the community. She's very remorseful regarding what happened. She's ready for this to be over. Her mental health has stabilized a great deal. She wants the court to know that. She wants to just get this over with some treatment. And so she's asking that you allow her to be released untethered to treatment.
People's response.
Your Honor, I'm going to be objecting. This is history of violence. She also has been contacting the victim of the domestic violence charge from in custody after being arraigned. There are 20 complete calls. So at this time, I'm going to be asking for phone privileges to revoke, given that she is calling the victim, asking, what did you do that for? Blaming him for being in jail, bringing up the assault charges, knows she's not supposed to be contacting him, so she addresses that in the calls. She also has the failure to appear. That would give me concern that she will leave treatment or not come back to treatment, and she does have that hold out of the 22nd with bond denied. There's also another hold I saw on a 14A1 with bond denied.
Yes.
And a hold out of 15th for bond second for $100 bond. So at this point, I have concerns about her attendance in court and also that she can't comply with bond conditions, given that she is violating her bond in custody at this point.
And again, Your Honor, my client understands the severity of her situation and circumstance, and she is very inclined to participate as in bond as the court would request at this point.
As to the circuit court arraignment.
Yes, Your Honor. She's been arraigned today.
Circuit court.
Oh, sorry, I got caught up in the bond thing. Yes, Your Honor. Your Honor, we would waive the reading of the. I know. Waive the reading as to the information, Your Honor, and we would plead not guilty as to charges. I forgot we waived.
Defendant having waived formal reading, pleading not the court will enter that plea. Pre-trial in these matters will be set for June 22nd, 2026, 1:30 with Judge Hamoud in the Possession case, motion for bond reduction is denied. Bond will continue as set in that case. In the other matter, the motion, defendant's motion for bond reduction is denied. People's motion to restrict or revoke her phone privileges and texting is granted. Her motion to reduce the monetary amount of her bond is denied. And quite frankly, given the circumstances, I was going to revoke it, but I'll just deny it at this time because Judge Shamudu has a handle on it.
Can I speak to my lawyer, please?
Devin, I will try to see
You
later
available all?
if possible.
Huh?
All right, thank you.
What did you say? What did she say?
She said she will be down to see you as soon as she's available.
Okay.
Kind of. That's what I heard. Yes, let me get these to hand because I got, yeah, no. Yeah, let's get them to hand and then. Court does call the case, People versus Rashid Abdullah.
For the people, Your Honor. And Assistant Public Defender, Tamika carry out the Your Honor, on behalf of.
Oh, here we go.
Mr. Abdullah, state your name for the record, please.
Rashid Abdullah.
Rashid, you said that last time. Your Honor, we respectfully request that this matter be set for preliminary examination.
Right. So discovery is complete.
To our knowledge, Judge, yes.
All right. People have their witnesses available on the 23rd. Preliminary examination will be set June 23rd, 2026, 9 a.m. before me. In person.
Thank you, Your Honor.
Bond will continue. Thank you.
Thank
you. Court calls case, People versus Lawrence Buckner.
As on behalf, Your Honor.
On behalf of Mr. Buckner, Your Honor, I would ask that we pass the matter. Mr. Buckner is, I just texted him, he is in the building. So you could pass it very briefly.
What's that mean?
Pardon?
What's that mean? He's in the building.
I mean, I'm understanding he's in the courthouse. But just not courtroom yet. Oh, he's taking care of some personal business at the moment. Just have a moment.
I'll pass it. Thanks. Court calls the case, People versus Aliyah Benton.
Good morning, Your Honor. James Fifelski on behalf of Aliyah Benton, who is approaching. Morning. Can you state your name, please?
Benton.
Thank you.
May counsel approach briefly?
Briefly.
Thank you.
Counsel approaching briefly is seldom brief in Judge Simpson's court, so let's take a minute and head over and say good morning to Judge Middleton.
Good morning. Are you Sarah Hut?
Yes, I am.
This is Judge Middleton. We haven't met. You were set for a pretrial conference today, and I didn't have you brought over because we've got a really small holding area and it's real hot in there. So I had you brought in by Zoom. Also here with me is the Chief Public Defender, Jeanette Jackson, from the Prosecuting Attorney's Office. Excuse me, from the Public Defender's Office. Ms. Hudson, you got charged in a formal complaint with a retail fraud in the second degree. It's alleged that on October 27th of 2025, you and a co-defendant, Mr. Brooks, stole $825 worth of trading cards from Myers. That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. That's the allegation. there is a video of this that allegedly shows this. Judge Pattison set the bond at $500. You got arrested on June 4th, and they set the matter for pretrial today. How did you come to get arrested on this charge?
I had turned myself in on some other charges because I knew I had a lot of charges that I needed to face and just get done with so I could take care of business. I was going through some things and it was wrong and I had to face my.
Where did you turn yourself in? Did you turn yourself in St. Joe County or Kalamazoo County?
In Kalamazoo County. Well, Kent County. I was in Kent County first.
All right, about when was that?
In December.
And when did you go to Kalamazoo County?
The April 30th.
April 30th?
Yes, sir.
And then to St. Joe County 8 days ago, then June 3rd. All right, so you've been in jail, one jail or another, since December.
Yes, sir.
All right, so let's talk about this case. This is a Centerville Three Rivers case from October 27th of 2025. Retail fraud, second degree, is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $2,000. Prosecutor has not made any plea offer in this case, so we don't have an offer to put forward. Here are our options. You can ask me to appoint a lawyer for you and I'll set it for a pretrial a little later this month, or you can plead guilty and I'll ask you some questions to make sure you are guilty and that you understand what you're doing. So here's our options. If you plead not guilty, I won't be offended or mad. It's your absolute right. I'll appoint a lawyer to help you with this. If you plead guilty, I'll take your guilty plea and then we'll see what we're going to do about a sentence. What would you like to do?
Plead guilty, sir.
All right, let me ask you a couple of questions. Anybody threaten you to get you to plead to this?
No, sir.
Or promise you anything?
No, sir.
Do you understand that by pleading guilty to this charge, you're going to give up your right to have a trial in front of a judge or jury? There will not be a trial. Do you understand that?
Yes, sir.
If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf. All right. If you had a trial, you'd have the right to testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes, sir.
All right, sounds to me like you're just tired of all this and you want to get it over with. Were you struggling with some drug issues?
Yes, sir. And in this relationship for 5 years, and I had just got away from him and we were a wrong crowd, and it just went downhill from there.
All right, what drug was it? Methamphetamine?
No, it's heroin.
Oh. All right, well, did you go into the Myers store on this day, November 1st, with Mr. Brooks and put a bunch of trading cards in some totes and walk them out the door.
Yes, sir.
And you would agree they're worth more than $200?
Yes, sir.
What would happen then? What did you do with these cards?
We took them to a friend and they sold them.
I show a Sunnyside Drive, Kalamazoo. Is that still a valid address?
Yes, sir.
Who lives there?
My godmother.
Well, I'm good. Glad you got a place to go here. I'm gonna set this for sentencing. I want to get more information. For June 17th at 10 a.m. We're gonna be real busy that morning. Are you done with Kalamazoo and Kent?
Yes, sir.
Do you have charges pending anywhere else?
Out of state.
Which state?
Indiana.
From what county?
I'm not sure, a couple counties.
All right, well, all you can do is take care of these things one at a time, which is what you're trying to do, and I respect that. You didn't beat around the bush, you didn't minimize it, you just owned it. You got 6 months clean time now, and you're thinking straight.
I also joined the MAP program, so that way in counseling and,
You joined it here in St. Joe County or Kalamazoo?
I'm in Kent County.
Are you on any medication now?
I'm actually sick, I need to have surgery done on my kidneys, so I need medications and.
All right, well, let me look into this. I'll get the police report, check on these other things, find out about whether there's a hold on you from Indiana. And we'll address it next Wednesday at 10 o'clock. All right, Ms. Hudson, sounds nice to meet you. I'll see you on Wednesday.
Yes, sir.
All right, this next guy, Jeffrey Kopp, let's see if they put him in my queue. He is a bench warrant arraignment, and Jeanette, I always appreciate you doing these.
Can I have the file number for?
The last lady, Sarah Hudson, is 252540. Jeffrey Kopp is 22110 SM.
Is it ST or SM on Hudson?
SM.
SM? Okay. How do you spell cop? Is it?
KOPP.
Oh, KOP.
No, I mean, yeah, KOPP.
Yeah, okay, I had a C, okay.
All right, Mr. Kopp, let me get squared away here. Good morning.
How you doing?
I'm doing all right. All things considered. You're probably doing-
Actually, I'm better now. I get this behind me.
All right. Here, Mike, refresh.
Audio is messing up.
All right, can you hear me?
Every once in a while.
Well, I'll try to speak clearly. You got arrested on a bench warrant on a charge of retail fraud in the 3rd degree. It's alleged that on January 15th of 2022, you stole some knives, batteries, camera, saw blades, and headphones from the Menards store. That's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. You got arraigned on that charge, and then you failed to appear for your pretrial. You had an attorney who was Melissa Halleck. She was a wonderful young lawyer and person. She was a public defender for a while, and then she came to work for the prosecutor's office. Anyway, she was killed in a traffic accident.
Oh, my God.
Yes, it was terrible.
Wow.
Anyway, you've been AWOL for 4 years until they finally caught up with you. So let me ask a couple of questions. How did you get arrested last night?
Oh, I'm staying on Wilbur Road now. And this truck kept driving by. And he must have thought that somebody was breaking in. But I've lived there for the last 3 months with Jim. And so the truck must have called the police, and they come to see if there was a burglary, and there was no burglary.
You're living at Jim Roberts's house? Oh boy, he's in jail. He's really having a hard time.
I know, it's the only place I got to go right now.
Well, I was told there were a couple guys living on the porch. Were you actually living in the house or staying on his porch?
No, I'm staying in the bedroom in the house.
All right. Does it have any electricity?
Not yet, but he got the wiring fixed to get it hooked up. And like I said, I've been there making sure he takes his meds, and he must not have took them the other day because he took off on it.
Does it have any water?
There's a picture, there's a pump. And then when it don't work, I go to the church and get water.
Who else is living there?
There's nobody else. I got my stuff all there now, and it's probably going to get stolen, my money, and my clothes, and everything. It's going to get probably taken from me again.
Well, you also have another charge, which I'm not yet clear what it is, that the magistrate is going to see you on later. As you know, Mr. Roberts has got significant mental health problems, and he was acting very strangely and bizarrely at the UAW picket site, and he got arrested. And he is not. We weren't even able to arraign him because he was so uncooperative. So let's talk about just this case. Let me see if this is an old retail fraud where it's alleged you stole this stuff from Menards. You had a lawyer appointed to represent you. She's no longer with us. Jeanette Jackson from the public defender's office is here, but she's not actually representing you. She's just looking out for your rights. Do you want me to appoint a lawyer for you? Or do you want to just plead to this old retail fraud?
I can just, there was only 2 nights. There wasn't anything else stolen from Menards. I don't know. That audio screwed up.
All right. Do you wish to plead to that, or do you want to continue your plea of not guilty?
Well, I just like to get it over with.
All right. Well, let's talk about that. Let's talk about the allegation again.
Okay. I want to get it behind me, so. I can't hear him.
All right. Well, I didn't say anything.
No.
Let me look, see if I can find out what the new charge is. How did you end up at Jim Roberts's house?
That's the only place left I had to go, and I met him about 10 years ago when he was better. And he needed somebody to make sure he takes his pills, so I tried to move it and help him. So he doesn't take off on and do some crazy stuff like this.
Which is what he did.
Yeah, I can't believe he just was brought home the other night by the 3 Rivers police, and he was down on the ground rubbing my
Yeah,
ex-girlfriend.
nobody knows what to do with him, including me. The VA's been working with him. But he's needs some serious services. I can't tell what your new charge is.
It might have been a watch at Walmart.
All right, well, anyway, you had some other charges back in 25, but this one.
I know I ain't been in trouble in 30 years.
Was back in 2022. The allegation is that you were in the Menards store. We don't get a lot of cases from Menards, but we do get some, and for reasons I don't understand, people often steal knives from Menards.
Well, I wasn't even planning on stealing it, sir. I put it in my back pocket.
All right.
And I was going up to pay for me. They were only like $3 a piece. I wasn't gonna steal nothing like that. Hell, I had $80, $90 on me in my pocket. I was going to pay for them. He thought I was gonna take them.
I was looking for an affidavit or something to support the facts. Well, you ain't telling me nothing. You're just blowing smoke. I didn't steal them. I wouldn't have stole them. They're only worth $3. I accidentally put them in my pocket. You're not owning it. So you can't plead guilty.
Well, that's what happened. I put them in my pocket. I was going to pay for them, and I was checking this battery charger out, and he come up around the corner on me. The security guard.
Okay.
And he must have thought I was stealing them. So.
All right. Well, there's no factual basis for a plea.
Oh, no.
I'm going to appoint a new attorney. I'm going to set an attorney pretrial conference for 6/26/26 at 8:30. Judge Pattison set the bond at $500 cash or surety. You've been AWOL for 4 years. You got a new charge. The irony is, I probably would have let you out if you'd entered a plea of guilty, but I'm gonna leave you in light of the new. No, you didn't. You said, I want to plead guilty.
You I want to get.
Told me you didn't steal anything. So I'm gonna set this
behind me, sir.
Yeah, by blowing smoke up my.
No, I want to get behind me. I will plead guilty.
Well, we'll talk about that once you get some legal help. June 26th at 8:30. He's got a new charge, which I'm not exactly sure what it is. He's right, though. His property's not safe in that house. We'll see what she does on the other thing. He's also got $595 worth of other unpaid fines and costs. I couldn't find an affidavit, but whatever he was telling me did not amount to a factual basis for stealing anything.
You know, friends, there might have been a time before we all started watching court on YouTube where somebody could have gotten away with pleading guilty and then saying, I didn't do it, I just want to get it over with. And maybe there's judges out there that would let that slide through, but we're not seeing it with the judges we watch, that's for sure. Good morning once again, everybody. We're now in hour 2 of TCF Live on this fine Thursday. I hope you're enjoying the court action so far. Let's head back to Judge Simpson's court, check back in with him.
Hopefully you get that tomorrow. Okay, Mr. Pipowski, you may, oh, go ahead. We're good.
We're all set. Thank you, Judge.
Okay. Court recalls case, People versus Lawrence Buckner.
Pattison on behalf of the people, Your Honor.
Abdullah on behalf of Mr. Buckner, who is approaching the podium. Mr. Buckner, when you get up here, please say your name for the record.
Good morning, Lawrence. Thank you.
Okay. And Your Honor, we are working on discovery. Ms. Senda did give me some more videos, but it's my understanding that we believe there may be some more out there. So we are asking for an adjournment at this time. The court should be in receipt of my green sheet.
I am.
Where I talked with, I got his, yeah, I'm waiting on him to check with other agencies that were involved to make sure we have everything, or if there's anything outstanding.
Okay, so the 25th would be two. You need more time than that, you think? Make sure.
20, okay.
Probable cause conference will be adjourned to June 25th, 2026.
Thank you, Judge.
On continue. Thank you. All right. Court calls these cases of the People versus Robert Lassner.
Morning, Your Honor. Raymond Cook.
Probably on behalf of Mr. Lassner, the case ending in 6.
Can you hear me?
And Assistant Defender Natalie Pate with an on behalf of Mr. Laster in the other two matters. Sir, we can't hear you. Could you please state your full name for the court?
My name is Robert Lassner.
Thank you, sir.
We were trying to accomplish pleas in all three of these.
Yes, Judge.
Yes, Your Honor.
I believe the court should be in receipt of a.
But one of them was not sent to me. Because
case.
I don't have your case. I have a plea form.
Judge, I thought I was on a part of an email where Mr. Cook had sent it to the court. I do have it. I can send it to the court right now.
Okay. Just so that you understand, this is, he's not anywhere, is he?
Correct.
No, he is appearing via Zoom.
All right. Let's have him. Are you here during the noon block? Because I don't want to hold it up. The report doesn't even come to me, so I'm gonna have to take time to get.
Oh, understood.
But I'd like to, I can do it one of two ways. I can either put him into, get the plea form to me. We can put him into a later block. Okay, if he can do that. Or what I can do is just put this out a week and take care of it then. Well, since this isn't his fault, Mr. Laster, which would you prefer?
Yeah.
What do you say, Your Honor?
So which would you prefer? You want me to put it out? I've got to put you either into a later block or I've got to put you out to next week.
Yes, we can come back at noon, or the court needs some paperwork that we need to get to them. So do you want to come back in a week or come back at noon?
Whatever is convenient for you, Your Honor. Whatever's convenient for you.
Mr. Laster, nobody ever cares about
the client.
I appreciate that.
Yes, sir.
Why don't we later? Because I've read these other ones. Yeah. So if you can come back about 12:30 or so, sir.
12:30 on Zoom, Your Honor?
Yes, sir.
Yes, sir. I can sure do that. Yes, sir. It'd be
all right.
Yes, sir. I can do that.
Okay. Thank you.
Oh, thank you, Your Honor.
Thank you, Mr. Laster.
You're welcome. You're welcome. 12:30 here.
Court calls case, People versus Michael Bank.
People. Good morning, Your Honor. Assistant Public Defender Davy Leba for Mr. Bank, who appears from the Oakland County Jail.
Okay, so Oakland came back. Okay. Sir, state your name.
I agree with Ms. Willenbrink.
What?
That's not Mr. Bank.
Sir, the gentleman at the Oakland County Jail, what's your name?
Jesse,
Say again.
Jesse,
That's not on our docket. Okay, sir, what, do you know what proceeding you were supposed to be appearing for?
No, I don't know.
All right. Can we have a direct line to contact them? Because I don't know. All right. Okay, sir, just sit tight. I don't think you're on my docket. All right. But this gentleman, Mr. Bank, is on my docket.
Correct, and is at the Oakland County Jail.
So they may just have to switch out. All right, we'll figure it out. Okay, thank you, sir. Court calls the case, People versus Kristen Berg.
And Assistant Public Defender Nicholas Buckovich, Your Honor, on behalf of Ms. Bird.
Correct.
I am, Your Honor.
All right. Your name?
Christian Berg.
All right. And order is it filled out? That's it. This is the competency hearing. Go ahead, sir.
Yes, Your Honor. We're here today for a competency hearing. The defense is in receipt of a report dated May 21st, 2026, written by a Dr. Aaron Serzine that finds that my client is competent to stand trial. So we will stipulate to the findings of the reports.
Any other additional evidence from the people?
Stipulate to the report as well.
All right. Based upon that report, the court would find that the defendant is competent to stand trial, specifically that she can understand the nature and objects of the proceedings against her and can rationally assist in her defense. Therefore, the defendant is deemed competent. So, sir, what would you like to set for?
I would ask to set this for probable cause conference. It's for a brief adjournment to finalize some discussion with the prosecutor and paperwork for an offer.
Probable cause conference then will be set for June 25th, 2026, 9 a.m. Bond continued.
Your Honor.
Those ones.
Jillian, I got something to Allie.
Or was it? Oh, yes, it was that.
Yeah, he's in front.
Thank you. Good morning. Court does call the case of the People versus Benjamin Spike.
Ready to go for the people, Your Honor?
Good morning, Your Honor.
There he is. Okay.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Spike.
Mr. Spike, can you state your name, please?
Benjamin Paul Spike.
Thank you.
Your Honor, we will be requesting an adjournment for further negotiations, and we'd also like to address bond.
Okay. Probable cause conference adjourned without objection to June 25th, 2026, 9 a.m. As to bond.
Your Honor, Mr. Spike originally had a personal recognizance bond in this matter. He missed his previous PCC date to lack of transportation. His father is now actively involved in the case. His father did call our office. I called his father's name out in the courtroom. I'm not sure if he heard. There he is. I thought that might be you, but I don't think he realized I was calling him at the time. But his family is here. It's my understanding from Mr. Spike, and I think they can confirm that they will help him get to and from court. And that would address the rehabilitation problem that he had that resulted in him missing court previously. He has, it is my understanding that he has no prior felony convictions and he does not have any assaultive convictions in the past.
Sponsor the people.
I'm just seeking a assault motion. I believe he pled no contest to a misdemeanor domestic violence in 2026 already. But beyond that, we need a discussion.
All right, thank you. How did he come into custody?
According to the notes in the from the arraignment attorney, yet I believe he was walking down the street and was a little unusual and drew attention and they discovered the warrant.
And he got picked up on?
I believe he's been in custody almost a week.
All right. I will grant that the previous bond is reinstated with all of its conditions.
Great, thank you.
I think that was that was a 5,000 year. Got that.
Thank you.
Thank you. Court does call the case People versus Michelle Schaffner.
Excuse me. Excuse me. Excuse me, Your Honor.
Yes, sir.
What is the bond set at, please?
I just said it. I just reinstated your previous bond before you didn't show up.
Oh,
so you had a $5,000 personal recognizance bond.
I understand. Thank you.
You're welcome.
Christina Costantino on behalf of Michelle Schaffner, who should be present via Zoom. Ms. Schaffner, can you unmute and state your name for the court?
Michelle Schaffner.
Oh, there she is.
Your Honor, this is a date and time set for PCC. We're asking for an adjournment of the PCC. There may be some outstanding discovery that the people and I have been discussing over the last couple of weeks that we want to make sure we have before moving forward.
25th will work.
It does, Judge.
During this matter, June 25th, 2026, 9 a.m. bond continued.
Thank
you. Court calls the case of the People versus Michael Grimaldi.
James Fifelski standing in for attorney of record Robert Ellman on behalf of Mr. Grimaldi, who is approaching. Can you state your name, please?
I'm Michael Grimaldi.
All right. You don't have a problem with Mr. Fifelski stepping in?
No.
All right.
This will be a waiver, and I believe there's a plea offer that will be finalized in circuit court.
That's correct, Your Honor. I did extend an offer to plea to an added clause 3 of an agreement. That he would serve additional time served or sentence as one counts to 1 and 2. That is not a conditional waiver, though. Should something happen up in circuit court, that offer could be.
All right. You understand that, sir?
Yes.
All right. Talk to Mr. Ellman about that too.
Yes.
All right. So, sir, you're waiving your right to a preliminary examination. You understand that that's a proceeding where the people would have to show by the standard of probable cause that the offense alleged was committed and that you committed.
Yes, Your Honor.
All right. You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
People, for the record, also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on count 1 with 2 following. Mr. Fifelski.
As to the arraignment, we will waive formal reading and stand mute as to all charges.
And in every way, formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
June 25th at 1:30 for Judge Slay.
June 25th, 2026, 1:30 for Judge Flay. Bond will continue.
Not guilty. So far, it's not guilty.
Court calls the case.
Thank you, Your Honor.
Michael.
Your Honor, Court of Active Funding Commission practice to Michigan Court Rule 8.120 under the supervision of Prosecuting Attorney Rashid.
Where are you from? Yeah, all right. Prison practice is granted.
Christina Costantino appearing on behalf of Michael Smith. Mr. Smith, can you please unmute and state your name for the court?
Michael Smith.
Your Honor, it's the date and time set for PCC. I have discussed with my client his right to have a preliminary examination, and that at that preliminary examination, the people must prove probable cause that he committed crimes alleged. At this time, he wishes to waive his right to a preliminary examination after our discussions, and understands this matter will be bound over to the circuit court for further proceedings. I would also indicate that there have been some negotiations that have helped facilitate this waiver. I don't know if the people wish to state those on the record or not. I can state them on the record if the people wish. Thank you. Your Honor.
That to her.
I don't know. I should have just said it.
On purpose.
No.
Don't worry about it. I got you.
Sometimes they let say it. I don't want to step on anybody's toes.
Oh.
Your Honor, so pursuant to a waiver here at the district court, we have reached a resolution where Mr. Smith would be able to plead to counts 1, 3, and 4, 1, 3, and an added count 4 that would be taken under HIDA, and count 2 would be dismissed. And that would occur at the circuit court. And of course, we would need to waive the exam to facilitate that offer. Is that your understanding, Mr. Smith?
Yes.
All right, Mr. Smith, everything that your counsel indicated regarding the examination waiver is true, sir?
Yes.
Okay, you understand the nature of that proceeding and that it won't happen, right?
Definitely.
All right. People also waive their right?
Yes, Your Honor.
All right. Preliminary examination having been waived, defendants bound over to circuit court on all 3 counts.
Your Honor, he stands mute and waives a formal reading.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to those charges. Pre-trial in this matter will be set
August 4th at 1:30 with Judge.
August 4th, 1:30 before Judge County. Bond will continue.
Thank you very much, Judge.
Yes.
Thank you.
There isn't one in the file for whatever reason. Court does call the case People versus Christian Luckett.
It's Michael Getty, the public defender on behalf of Mr. Luckett, Your Honor.
Usually I list them. False. Your name, sir?
Christian, me or him? You or me? Christian Luckett.
All right.
Your Honor, this is the time and date set for a competency hearing. The court adjourned it for a week last time so I could further confer with Mr. Luckett and the attorney in circuit court. I have done so. We are stipulating to the report.
All right. Any additional evidence for the people, or do you stipulate also? Based upon a review of that report, the court would find that the defendant is competent to stand trial. Which specifically indicate the defendant can understand the nature and objects of the against him and can rationally defense. Therefore, he's deemed competent. I have signed the order.
Okay.
What would you?
No, I had prepared. I had one just in case. That
Wow.
Didn't have one in the file.
Thank you, sir. So well prepared. All right. What would you like me to set this for?
I think if it's okay with the court, I think we'd ask for an exam.
You're ready to proceed and go forth?
Yes.
All right.
Informed of that.
So discovery is complete.
Yes.
We'll have their witnesses available the 23rd. All right. Preliminary examination will be set June 23rd, 2026, 9 a.m. before Judge Freshour.
Thank you, Judge.
Bond will continue. Thank you.
Thank you, Your Honor.
Okie dokie, friends. Let's change it up as we are halfway through episode 309, I think, of TCF Live. Let's check. Yes, episode 309. We just keep piling them on, don't we? Let's go to Texas, Judge Boyd.
All right.
And is there just a plea to one case?
Do it.
And who's the attorney?
Gary, sure.
Yes. There needs to be a file stamp on that, please. You were out of position.
I was multitasking.
Cindy, you ready?
Yes.
Court is calling 2026 CR 002-999 State versus Brianna Owens. Could I have parties announced?
Gary Check for the defendant.
And are you Miss Owens?
Yes, ma'am.
And is this an application?
No.
All right, probation, no application. Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Owens, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We waive.
State, are you proceeding on the indictment as presented?
Here's to leave abandoned count one to be solely on count two and also leave an abandonment function.
Any objections?
No objection. Understand that.
Yes.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
The state is proceeding on count two. That's possession of controlled substance penalty group 1, 4 to 200 grams. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does, Your Honor.
Do you believe she's currently competent and was sane at the time of the offense?
She is, Your Honor. And she was.
Ms. Owens, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count two. Punishment is to be assessed at 4 years in the prison. There's $1,000 fine. There are no applications. They're taking in consideration 2026 CR 002-997. And there's $120 restitution to the Bexar County Crime Lab. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
There are none, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor. Receipt of receipts exhibit 1 and all attachments.
No objection.
State you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
Ruben card. Under every day, all day. So, yeah, something happened. I had another thing. Well, something I wrote for that chair.
All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We'll wait, PSI, Judge.
Anything you wish to say on behalf of your client?
Just to follow the plea bargain, please.
Oh. The court is going to follow your agreement, sentence you to 4 years in the prison. There's $1,000 fine, time and money to run concurrently. Taking consideration 2026 CR 0022997. There's to be restitution of $120 to the Bexar County Crime Lab for testing. There's to be no contact with Juan Arizola, Arizola. There's to be no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. Do you understand?
Yes.
All right, so here's the thing. How old are you?
I'm 39.
All right. So you're gonna have to start making some decisions, because now if you have another felony, depending on the type of felony, your minimum is gonna be 25 years. Okay?
Yes, ma'am.
So start making better decisions, all right?
Yes, ma'am.
And if there's a drug or alcohol issue with you, when you're released from the prison, there are plenty of places that you can go to. And if you can't find a place, let me know. I'll pick up the phone and call somebody, okay?
Yes, ma'am.
All right, good luck to you.
Thank you.
What? Oh, here.
All right, who's next?
Automatic, yeah.
Christopher Medellin.
Present, yes. I conferred with Brandon. There's an unindicted ag robbery charge that I think is going to control. Brandon said he sent an email to, it's a 701 case. So he sent an email to the intake. Yeah, I'm going to file a motion for examining trial to see if we can expedite things, but that's kind of what's in control right now. So we'll just ask maybe a 30-day to monitor the other case, and I'll try to make contact with the intake attorney as well.
Okay. Ms. Ferguson, I need 30-day reset.
Works for me, Judge. Thank you.
And are you on the other case?
I'm off the list now, but I'm sure I'm on those right now.
All right, Norma, can you make sure he's on that case?
Yes. Are there 2 at-large cases?
Yes.
If I'm not, I see really qualified court appointed lawyers here, Judge, much more qualified than me.
Oh, he jokes. All right, we'll see you back on the 13th.
Thanks, Judge.
You're welcome. All right, now, who's next?
Yeah, Christopher Johnson, page 4, 2 down.
Christopher Johnson. Then after that, if we don't have anything left, then I can take the off docket matter.
Just one more.
Okay. All right, State, were you able to tender an offer?
Judge, I'm still going through some items, but I have tentatively discussed something with defense counsel, just like I have one more discovery set that I appreciated.
All right, I'll have you all discuss matters off docket. I'm going to set the plea deadline date. Norma, give me a date for plea deadline date in 45 days.
Yes, that would be July 25th.
All right.
I will be out of state still,
Oh, that is so true. When will you be back?
August 10th.
All right, Norma, set it after August 10th.
Thank you, ma'am. I'm very heavy that day. If you could do it the day before, I'm fine. That's fine.
All right, so we'll be back on August 11th. On that day, you need to let me know whether or not you've reached an agreement with the state. All right, thank you. Once you sign the reset form, you're excused. You're welcome. All right, who's next?
We have Julie Pierce, case 8 was on the bottom.
Julie Beers.
Yeah, Judge.
Yeah. And where's your client?
Client is not here, Your Honor. This is an affidavit of surety.
Mhm.
I've never had contact with her outside of the first jail visit we did, and they actually just, we can't get in touch with her.
Okay, well, I'm going to sign the affidavit.
Not a problem, Judge.
All right, thank you.
Have you excused?
Yes.
Thank you, Your Honor.
All right, friends, I will keep an eye on Judge Boyd's court. We might come back later on, but let's head back up to Michigan. We'll say good morning to Judge DeSanto.
To the judge.
Jennifer Lynn Brardy.
Okay, good morning.
Morning.
So today is the date scheduled in this matter for the adjourned probable cause conference
No, it's actually exam, but we're,
or preliminary exam. Okay, and so council, there's been a resolution in this matter.
yes, Your Honor. Yeah. Indicated since arraignment, she'd like to participate in treatment court and especially mental health court. I think she's a suitable candidate. There's also an email in there which I reviewed with her, and she has issues that will be a challenge to this court and a challenge to her, and she knows that she faces up to a year in jail if she flops and doesn't manage it. She blew an 09. If the court accepts the added count of second offense operating while intoxicated, also indicates the blood draw that there was alprazolam, which I find out is the equivalent of Xanax from system that day. And Mr. No, I don't just say anything. I know you're prescribed. You're going to take the plea. And you're going to participate in the court hearing. If you don't, you read this agreement, you know that it says you'll go to jail.
Yes.
You fail. Judge, we're ready to present the plea to have her question.
Okay, how do you know Mr. Shazer?
I met him through a friend's friend that he had represented before.
Who's?
No, she thought you were talking about me.
Oh.
I'm sorry. No.
No, how do you know Ms. Gabrielle DeShazer?
I don't know her. I don't know Gabrielle's decision.
Well, Mr. Shazer seems to know a whole lot about you.
I know a Gabrielle Mendez.
Okay,
Is it the same last name?
I don't know if she has a different last name or not. But in any event, she sent in a communication that council referenced yesterday afternoon, which I did not see until
Oh,
just
did he?
this
Yeah, I
morning.
never-
So just, hold on, only one of us can speak at a time, ma'am, because I can only get one of us, okay? Okay. Ma'am, please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes.
And you've gone over this plea
Yes.
with your attorney, correct? As to the amended charge of operating while intoxicated second offense, how do you plead?
Guilty.
And you have gone over your rights your advice of rights with your attorney, correct?
Correct.
And you've also signed this document.
Correct.
Well, no, this you have not signed. This, you have not signed
I have a signed one here, Judge. I'm sorry.
for the advice of rights?
Oh, you know what? She signed the old one. I didn't.
I'm just gonna give this one to you right here to sign, because this is the one that's in the file.
Sorry, Judge.
That's okay.
No, we've gone over these rights and we're just gonna re-sign that one. This defendant. I'm gonna sign it just to affirm that I witnessed it.
Okay.
Thank you. She now signed it, Your Honor.
All right, thank you. And so, ma'am, you understand that by entering into this plea, that you'll be waiving some of the rights that you've gone over with your attorney, correct? And you understand as well the possible penalty as a result of your plea,
Yes.
whether in this court, any other court or administrative agency. Specifically, you understand, ma'am, that there is a sentence agreement that was made between your attorney and the prosecuting attorney of 30 to 90 days jail as determined by the judge if the defendant does not enter a specialty court or at the discretion of the court. The jail condition may be waived at the discretion of the court if the defendant successfully completes a specialty court program pursuant to MCLA 257.625, paren 9, paren B, and or paren C. Provided the terms of the agreement are satisfied, the OWI 3 charge will be dismissed.
You understand?
The sentence agreement continues on to say, to read, 2 years probation with sobriety, drug, veterans, or mental health court that the defendant will need to find placement on or before sentencing. No early termination of the probation or modification of the sentence can be made unless the defendant successfully completes specialty court. Any scale or approved sobriety or specialty court will be acceptable. The 27th District Court has an acceptable program. In addition, all other terms set by the court, cost of prosecution of a minimum of $500 or more, as determined in alcohol, drug screening, and treatment. Full restitution for any out-of-pocket costs for damages or harm incurred because of the offense on or before sentencing, if applicable. The department has filed a request for civil reimbursement for $125. If the defendant is terminated from sobriety or specialty court due to continued program violations, commits another crime while on probation, including a traffic or license crime, or the judge finds sufficient cause to terminate probation due to continued violations, then the balance of the year must be served in jail, no work release or waiver, which is non-discretionary with the court. An above violation can also be grounds to vacate the operating while intoxicated second plea agreement. And then also indicates that you will stipulate that the sentence agreement and third OWI offense are sufficient grounds for incarceration. If it's imposed, the judge must accept all the terms of this agreement. The offer is only open while the case is pending in the district court. All right, you understand the terms of this agreement?
Yes, John.
Knowing all of that, do you want to continue with your plea?
Yes, I do.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
Counsel, if you can please voir dire your client.
Judge, it's an old case. I forgot the date of arrest. If you would just,
February 4th.
pardon, once again, February 4th?
Yes.
All right, ma'am, on February 4th of 2026, you were operating a motor vehicle in the city limits of Southgate County, Wayne, state of Michigan. Is that correct? Prior to operating the vehicle, you consumed alcohol and had a prescription drug in your system. Is that correct? You have no reason to contest the blood alcohol score of 0.09 on the, which was a blood draw at the hospital. You believe it's accurate, shows where your blood was at the time you were stopped by the police. Is that correct? You understand that 0.08 is the threshold for being intoxicated. You were 0.01 above the level. You believe your ability to operate was impaired or intoxicated due to the consumption of alcohol.
Right.
Thank you, Your Honor.
Did that come through, Ellie?
Yes.
Okay.
And you understand everything else and you're ready to move forward. You hope you get placed in the mental health court here.
Yeah, and I hope to help my, other issues, plus the, mental health, plus the other issues I go through. And I heard good things about this program, so I'm really I'm thinking this is gonna be a good, I had some great things about this, that I really think this is going to help you. So I've been dealing with this my whole life.
All right, and it is a fantastic program. It's very intense and very individual effort focused, which means that you have to put a lot of the work in.
And that's all how you get better.
Right.
On the person.
Correct. All right, the court does find the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge, dismiss the original charge per the plea agreement. Ma'am, if you test right now, what is in your system?
Just my prescriptions.
Which are?
Adderall, my Xanax, Vraylar, like the propapanol. These are my like other medications that
Okay,
I submitted my other medication.
I understand.
Something that when I drug test, because I don't
Okay.
need randoms right now.
Yes.
I,
Let me ask you this question, ma'am. Are all of your medications prescribed by one provider?
my psych meds are, the only medication that is prescribed by my PCP is my blood pressure medication.
Okay, everything else is prescribed by your psychiatrist?
Yes.
Okay. All right.
I have a question. I don't know if I should ask Ken.
Talk.
Okay.
It's not regarding your plea, something about what you're doing here, right?
No.
Right.
It was, if we keep getting calls, but I don't know this girl, what do we do?
I'll address that.
Okay, okay.
All right. So ma'am, if you test right now, what is in your system? Other than your prescription medications?
It would be my Xanax and my Adderall, my Vraylar.
Would there be anything that's not prescribed?
No, absolutely not. If you'd like me to take a drug test.
When's the last time you tested?
Yesterday.
And have you used any nitrous oxide?
No, I have not.
Okay.
Judge, would you make that clear? Because that's also fatal in her
I-
age for huffing. I know, I read it all, and I told you. And
I don't want to screw nothing up, and that shows up in drug tests. I'm not using anything. I was with my child. You know, we went to like carnivals and a wedding, like there's.
Okay. All right. Bond and conditions are continued, and you're going to go overdue probation for all of your next steps. Okay.
I'll see you outside.
Okay.
So go right to probation.
Oh.
All right. Thank you.
Go sit down. Okay.
And this is the Zelmac show today with all the cases we have.
I'll be short-winded for once.
Okay, and so we are on the record in the matter of the City of Wyandotte versus Ada Nemeth, 26354.
Zelmack, on behalf of the defendant, Mr. Nemeth, please give your name to the judge. Name number.
All right, and good morning. And today is the date scheduled for sentencing in this matter. And thank you for dressing appropriately for court. And counsel, did you have an opportunity to review the report and recommendation with your client?
I have, Your Honor. We have no additions, no corrections, no deletions. Mr. Nemeth, I'm ready to be done. If you don't want to add anything else, do you? You're shaking again. You're gonna fall over. You're all right. I forgot. All right. Do you have anything else to tell the judge? Or are you all set?
No, I'm all set.
You want to sit down? Or are you okay?
No, I'm okay.
Everything. Father could come properly up here if you want.
Do you have a medical issue, sir?
No, he's nervous, Judge, and probably good because he wasn't like really high on the intoxilizer, but this is a good lesson, but he's afraid that he's gonna mess up again.
All right, so if you test right now, what's in your system?
Nothing.
When's the last time you used marijuana?
March 17th.
Okay, very good. And how are you feeling?
Feeling good.
Feel a little bit more clear-headed?
Yeah, I feel a lot more productive too.
Yeah, funny how that works. Yeah. Okay, and so the court will note after hearing from counsel, hearing from Mr. Nemeth, reviewing the report, the recommendation, the court does find that there's reasonable grounds to depart from MCL 769.5. The court also finds the following sentence to be in the best interest of justice, to be reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. Nemeth and the legislative guidelines. The court's going to order 12 months probation. You're eligible for early discharge, which I will go over shortly. You're also eligible, you're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of this court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, in writing, or virtually. You are also to notify your probation officer immediately of any change in address or employment status. You are to not use any alcohol or drugs unless prescribed. You'll have to participate in random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. You are also to enroll and participate in outpatient substance use counseling. The rehabilitative goal for that condition is so that you can have assistance in providing coping mechanisms so that you may maintain sobriety, hopefully preventing this matter from happening again. You're a young lad, sir, and this is definitely not the way you want to start off your adult life, right? So hopefully these conditions will assist you in that. You also are to participate in the MAD Victim Impact Panel. The rehabilitative goal for that condition is so you can further increase your understanding of the dangers of driving while under the influence and the consequences of such behavior. And the court's going to order 5 days on the court workforce. The rehabilitative goal for that condition, sir, so you can further develop life skills and give back to the community. And so you're doing 2 part-time jobs right now, correct?
I'm only working on a landscaping job right now.
Okay. Is that more of a full-time?
Yeah, just whenever they need me, because I know they have like a lot of people already right now. So I just kind of fell in whenever someone called off or whenever that happens.
Well, that's not very consistent. Why are you not doing something that's more full-time?
I've been looking for another job.
Okay. Okay.
City of Lincoln Park's hiring, you might announce that too, Judge. You'll work, DPW, work the streets, work plumbing, work mechanics, so send you over there.
Okay. All right. Any questions regarding your conditions?
No, Your Honor.
The court's going to order a $300 fine, $100 screening assessment fee, $600 supervision oversight fee. That's $50 a month at 12 months. And since you're eligible for early discharge, up to half of that could be waived. $300 for the cost of prosecution, $75 crime victim assessment fee, $50 justice system assessment fee, $200 for the workforce. It's 5 days at $40 a day, which is a total of $1,625. You did post a bond and you can apply that bond and then you can work out your payment plan with probation for the balance of your payment. Okay, sir? Any questions?
No, Your Honor.
As I did state, you are eligible for early discharge as long as all the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations and all monies have been either paid in full or you've made a good faith effort toward making full payment. Okay? Good luck to you, sir.
Thank you, Your Honor.
Have a good day. All right.
Just about to enter hour 3 of TCF Live here on this Thursday. I hope you're all enjoying everything so far. If you're lurking out there in the chat and have not yet said good morning as I trip over my words, do us a favor, say hi. Let's go to Louisiana, checking on the board.
The order, today's date is June 11th, 2026. Time is 9:11 a.m. My name is Danny Barra, serving as your chairman today. My colleagues on my left are Mr. Killis and Mr. Adu on my right. We're here at DOC headquarters in Baton Rouge, and our remote location is Raymond, the Board Correctional Center. Is there any staff in the room? Please introduce.
Deputy Warden Nikki Shinbear.
Thank you.
Patient Raven Heath. Melissa Joshua Records.
Thank you. All right, and we have Mr. Smith. Mr. Smith, would you introduce yourself and give us your full name and DOC number for the record?
Yes, sir. Good morning. I'm Douglas Smith, number 373823.
All right. I'll give you a brief explanation of the hearing. I'm going to read some information, ask you to verify it. I'm going to give you a chance to speak. Tell us what you did that caused your incarceration and why you should be released. We're going to ask the warden. We're going to have some comments from the public. We're going to have some district attorney comments if they're available. And then we're going to allow your attorney to speak if you have one. So today we have for parole consideration Douglas Smith, DOC number 373823, who's a third felony offender who was convicted of DWI fourth 2 counts, armed robbery 3 counts, attempted first-degree robbery. And on October 26, 01, 12/12/07, and 9/22/08 was sentenced to a total of 90 years hard labor in St. Tammany Parish. Got a parole eligibility date of December 2nd of 2026. Good time date of 10/18/2095. Full term date of 5/15 of 2098. Does that sound correct to you, Mr. Smith?
Yes, sir.
All right. So the first question is, what are you doing to cause yourself to get that kind of a sentence? And what have you done while you're there to make us think that you should be getting out early on a 93-year sentence?
Well, sir, I can't speak about my charge without going to my past, because my charge has everything to do with drug addiction and alcoholism, sir. So that stems from an early childhood tragedies that I had gone through. I also suffered some depression from those tragedies, and I also suffered low self-esteem because I suffered academically as well. So it was fertile ground for an addiction, substance abuse problems. And if you will allow me, at this time, I'd like to address my victims.
And
That would be Mr. Burton, Mr. Neal, Mr. Hamad, Ms. Hart, and Ms. Kuzan. I'm deeply ashamed that I allowed my selfishness and immoral, addictive behavior get so out of control that it affected you in such a profound way. And when I say profound, it's exactly what I mean, because I can only imagine the fear that you felt that day. No one should have to go through that, ever. I can only imagine the depth and the magnitude of that fear. Through programs, I've learned the magnitude of my actions that day extend further than just you alone. I understand now it's also your family, your mother, your father, your children, your co-workers, your employer. My actions that day affected not only you personally, but them as well. And I can only imagine how long that, do you still is affected by that today? I can only imagine. I don't know, and I'm sorry that I don't. What I've learned in prison is that my alcoholism, as I said, it stems from childhood tragedies that were hard to cope with, and low self-esteem that resulted in immaturity about the way I looked at myself, the way I looked at life. I've had a long time to reflect on that root problem. I've learned through programs and just maturity in general that everyone goes through hard times. Everyone suffers tragedy, and we all have to deal with it some way, somehow. And when programs like AA and Living in Balance, you hear testimonies of people that have gone through a lot worse than I have. My pain is my pain. I learned that pain is part of life, and we have to be mature about how we react to that. Since then, I've become a man that's respected, a man that's sought for advice. I'm now, I've found my niche. I've found purpose in life, to whereas I've become a leader and teacher of men. Here at the board, I'm a welding instructor. And I've learned to teach not only welding, but I teach leadership skills, teamwork skills, of all walks of life, whether they're young, Christian, Muslim, all my students give me a lot of respect, and it's who I've become. It's who I identify myself as now. I no longer identify myself as that broken down, depressed addict in that cycle that was just continuously destroy me, and everything I tried. I finally found God. I found a purpose in life. I found a confidence in myself, and I live it every day. I'm an example to all of my students. And by the time they finish the course that I can teach, levels 1, 2, and 3 welding, we've become good friends, and they all respect me. Like I said, whether they're young, it doesn't matter. I can relate to them all. And my faith in God, my ability to overcome my depression, to overcome my insecurities and my low self-esteem, the 20 years that I've spent in prison has made me uniquely gifted in helping others. And that's what I will and continue to do if you allow me some freedom. I have sons that can benefit from what I've learned about life and myself and addiction and tragedy. I have the parole project. They're going to give me all the reentry tools that they have at their disposal. And my long-term plan is to hopefully parole out to Wiggins, Mississippi, Lumberton. Stone County is where I was born. It's my home. It's where my dad's entire side of the family lives. I have a job waiting for me there. I will be living with my dad's younger brother, who became a father figure to me after my dad's untimely death. And he lives alone. He's elderly, and he needs me there. And my cousin's willing to hire me as a full-time welder. He's does equipment service, so he gets as much work as he does mechanic work. My support system out there is pretty big. They're all positive. Successful people, sir and ma'am, and I really hope you consider my sincerity.
Thank you very much. Thank you. Horton, can you tell us about how his behavior has been there?
He's only had 12 write-ups since 2001 in his record. He has completed numerous ICB and vocational programs. Like he said, he's a welding instructor for us here at Raymond Board. He has taken anger management, living in balance. The only thing I would recommend if he is granted parole is that prior to that, he be enrolled in some type of long-term substance abuse program. As he said himself, he has battled with this addiction for most of his life.
Warden, may I ask, the 2021 write-up was for 14.
Yes, ma'am.
And that was after he took the living in balance and all of the other classes.
Yes, ma'am.
So that's a concern.
I agree.
Mr. Smith, can you tell us anything about that intoxication write-up on September 23rd, 21? After the treatment and all of that? Why was that happening?
Yes, sir. I died that day, sir, literally, sir, and scared the hell out of me. As I said, I had become very confident in myself and, unfortunately, I was still in a pity pool, because here I was, finally, I felt mature, I felt I could be successful, but I had messed up my life so bad that I had a 90-year sentence, and I still felt hopeless that I would die in prison, and I was in a pity pool, sir. And what I learned that day is never, ever, not even a little bit, ever. And I love life, and I'm bigger than that cycle of destruction. I'm a leader and teacher of men. That's who I am now, sir.
All right. We also have several letters of support in your favor that came in that are part of the file. We also have several people in support who are here in the audience, and we also have 3 people who would like to speak. Let's start out with Mr. Andrew Hunley with the Parole Project.
Good morning, Andrew Hunley, representing Louisiana Parole Project, informing the board today that we have agreed to accept Douglas as a client in our reentry program if he were to be granted parole. Obviously, we decided to take Douglas on as a client in light of his positive record of rehabilitation. We're especially impressed with who he has become as far as a mentor and leader of other prisoners there, and the way in which he, especially with the welding trade and the number of people he's been able to assist. He has served right at 2 decades in prison, and he has significantly matured. We do agree with that. We also share everyone's concern that we want Douglas to maintain his sobriety moving forward. While we do believe that for the last 5 years he has been sober, part of our suggestion today would be, in light that his PED date's not until December, so even if the board were to agree to grant him parole today, he has time to continue the work. So we would ask that as part of his reentry plan that he be granted pending successful completion of a long-term drug treatment program, that obviously he would not be able to be paroled if he would not complete that program, that if granted parole, he would have to reside at Parole Project at an amount of time that we would be confident that he would have to display his continued sobriety for a time determined by the board before he goes to Mississippi. Our staff social workers did a social work assessment, substance abuse assessment that should be in his file, where they gave some recommendations, but we want to make sure that he stayed with us long enough to work with our social workers to ensure that he has those tools, all the reentry tools, but also the tools to remain sober. And then upon that point, that we would apply for an ICOTS for him to go to his long-term residence in Mississippi. But we just wanted to let the board know we are confident that he is on the right path. We are confident that he is committed to his sobriety. We believe a long-term substance abuse program before he meets that, starting that before he meets that PED and having to complete it, even if it means completing it after that PED date, along with housing with Parole Project until a point that we're comfortable that he is working towards all of his sobriety goals, and then working with probation and parole to get an approved ICOTS addressed to Mississippi. Thank you.
Thank you. All right, we also have Tarzan Treadway, a friend who would like to speak.
Thank you for your time. I've known Douglas for 40 years. I've witnessed him in good times and bad times. Bad times have always been directly tied to addiction, as he mentioned before. I truly believe that years of reflection on his mistakes and how he got there have led to a full understanding that drugs and alcohol cannot be a part of his future. He learned from regrets his mistakes, believe that ownership is crucial and what he knows. He has to know that when we go forward. He's always been smart, hard worker, the leadership qualities and his determination to be successful. I believe this has been proven to be the case even while incarcerated, as he's earned multiple levels of legal certifications and he's now teaching. I believe he'd be a valuable asset to our communities. I know that Dale greatly desires to be a part of the boys' lives. So we talk about him often. If released on parole, he'll continue to have my support, and as you've seen many others. I'm confident that Douglas is prepared to follow the conditions of parole, continue moving in a positive direction and give it consideration.
Thank you. We also have Sarah Call, a friend who would like to speak.
Thank you for allowing me to speak on what this is to happen. I've known Douglas since middle school. We were friends throughout high school, and after that, we hadn't spoken in years. 4 years ago, we reconnected and began correspondence through email, phone calls, and visits. It's through these 4 years that I would like to talk about. Throughout the past 4 years, we have built a very strong friendship. I have visited him once a month. It's been during those interactions that I've been able to see a genuine change and sincerity that I believe can only be experienced by someone who has been truly humbled and broken. Not only have I witnessed growth in his character, but also a renewed mind and transformed heart. There has even been a transformation in his appearance over the years of our visits, which I believe was evidence of someone living with hope for a better future. He has tremendous grief over the lost years with his son, Douglas and Daniel, who are here today supporting him. And he desperately longs to reconnect with them as a father. He speaks of them often and earnestly hopes that they will be a part of his life. Instead of allowing bitterness and anger to grow during his incarceration, he has chosen to examine himself and to identify the root cause of his past behaviors. He has searched for the reason behind the hurt he caused himself and others. Taking complete ownership of his failures without excuses, Douglas has expressed sincere remorse and desire to redeem his life and restore what has been broken. The proof of his change is how he lives his life every day in prison as if he were free. He has established healthy habits and disciplines each day, including exercise, reading his Bible, and attending AA, NA meetings. He has earned respect from the students he teaches because of his work ethic, discipline, and strong leadership. Douglas is a very humble, hardworking, and loyal person. Everyone that knows him would agree. I believe he should be released so he can prove to everyone that change is possible when you take responsibility for your wrong actions and decide every day to choose to follow the right path. Thank you.
Thank you. All right, well, that's all the people we have speaking in support, but we do have several people in support here that I'd like to recognize. Miss Leon Lala, friend, Mr. Jason Smith, a friend at headquarters, Tiffany Kilborn, a friend here at headquarters, Stacy Smith at headquarters, friend, Shelley Forcade, Kyle's mother, here in support at headquarters, Daniel Smith, son, here in support at headquarters, Douglas Smith, son, in support at headquarters, and Christopher Greico, a friend, in support here at headquarters. Rebecca McLeod, friend, and Randall Carl, friend. Opposition, we don't have anyone here to speak in opposition, but we have letters of opposition from the district attorney's office, the sheriff's office, and the attorney general. So we have some law enforcement opposition.
Like asking.
Yeah, I have a couple of questions to, go ahead, yes, Susan.
Mr. Smith, I want to hear how you view your current state dealing with alcohol at this time.
It's my worst enemy in life, man. I'm not afraid to say that, you know, at one time in my life, peer pressure tried to tell me that I had to run with the big dogs, but I'm not afraid to say anymore that I can't even handle a little bit, not at all. I don't need it. It's not something I identify with at all, ma'am.
Are you an alcoholic?
In the sense that I'm a recovering alcoholic, most definitely. My past shows you that I've struggled with it most of my life. We're always an alcoholic in the sense that we can never fool ourselves into thinking that we can drink in moderation or sociably. People like me, it affects us differently. It's like an allergic reaction is what it is. And I just can't handle, not even a little bit. So I won't even attempt to try.
Phyllis, do you have any questions? So you're attending AA meetings regularly?
Yes, sir. I have for the last 3 years. Yes, sir. Once a week, 1 week, and then twice a week the next week. And I have been for the last 3 years. Yes, sir.
So if released, you'd probably be open to have a drink or socialize with some friends. Do you think that will affect you?
I will not be open to drink and socializing with friends. I can't handle it, sir. No. What I have in place is my support group is alcohol-free and drug-free. The uncle I'm going to stay with, the uncles that are nearby and the cousins that are nearby, we're all going to attend the same church. Mr. Jacob Smith, which is no relation, but he has agreed to be somewhat of a sponsor for me. And there's also in the town of Poplarville where I'll be working, there's a pastor by the name of Jeff Easterling. He has also agreed to be a sponsor to me. He has got experience with men coming out of prison and addictions. So he's a good sponsor for me, and I've already been in touch with him, and my sobriety program is in place, sir.
So you've been clean 5 years?
Yes, sir. Since that day, yes, sir. That was as I said, I died that day, sir, and death has a way with giving you a perspective on life, sir, and I love life.
Thank you. I'll move for an executive session.
I'll second it. So go ahead. Tim?
Yes.
Barbara?
Yes.
Yes.
Friends, it's clearly executive session week down at the board. I don't buy anything that guy's saying. Let me know if you see it differently in the comments. But the thing that got my attention was when asked if he was an alcoholic, he didn't just say yes, which is the proper answer there because he is. It's kind of a lifelong thing that you have to fight against. He tried to deflect, and not a fan. So we'll come back to the board in a few minutes once they get out of session. In the meantime, let us head back to Judge Boyd.
Pronounce your first name.
Rokes, come in.
Okay, I can't roll the R's today. I don't know why. It's not working. All right, counsel, have you received all discovery? Did you review it with your client?
Yes, ma'am.
Court will find that the state is in compliance with discovery. Mr. Roque, did you review, I'm sorry, Mr. Escamilla, did you review the true bill of indictment with your attorney? Did you understand it?
Understand it completely.
Counsel, do you waive the reading?
Yes, ma'am.
State, are you proceeding as presented?
Yes, sir.
Mr. Escamilla, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I did review it and I do comprehend everything underneath it and it's.
All right, you're charged with unauthorized use of a vehicle. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, ma'am.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Escamilla, has anyone threatened you, coerced you, and or placed you in fear to get you to enter this plea?
No,
Anyone promised you anything other than the plea?
no.
Are you satisfied with the way you've been represented?
Yes, I am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
I do understand.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, I understand.
According to your plea, punishment is assessed at 93 days in the Bexar County Jail under 1244. There's to be restitution to Brian, Briann Thornton, Thornton, of $500. Is there an anticipation that this is a judgment satisfied?
Yes, Judge, and I understand, and the complainant has to advise that amount. Paid or enforced.
All right. And does he have actual 90 days in?
He has 93 days, yes.
All right, thank you. All right, does everyone understand that to be the plea?
Yes, sir.
Do you understand that to be your plea?
Yes, I do.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I do.
Counsel, any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor. See offer states exhibit 1 and off.
No objection.
All right, state, you may be excused. Did you review, you're welcome. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, off the record for a moment.
Alrighty, everybody's just muting right and left here today. We'll come back to Judge Boyd. In the meantime, let's go back to the board and get that finished off.
All right, without objection, the board is resuming session, coming out of executive session. And just give you one more chance to say anything that you want, that you left out, that you want us to hear before the vote.
Well, my sons, I ask that you consider they're victims as well. They've had to live with the stigma of my actions. I ask that you consider my release while I still got some good working years left in me, and I can still got some good positive years to spend with my sons.
All right. The case has been assigned to me. So I am gonna cast the first vote, and I'm gonna vote to conditionally grant you parole on completion of the long-term treatment that Mr. Hunley was talking about before you get out. That you go to the parole project for 1 year. And that you do their alcohol and drug program there. That you do AA and NA meetings weekly for the entire period of your parole. And that you not drive a vehicle that is not equipped with ignition interlock. If you drive any vehicle, friend's vehicle, any vehicle, work vehicle that's not equipped with ignition interlock, and we find out about it, I'm gonna give you back the rest of your 90 years.
Yes, sir.
That's my vote. It's only one vote. Mr. Dew?
Mr. Smith, you were convicted under the law previous to the time change where you can write back. When you can explain that to him. He can write back within 2 years. My vote is to revoke, to deny today. I need to see a longer period of sobriety within the prison setting. I would hope that there would be an opportunity maybe to do living in balance again. 20 years is a very long time, but the fourth DWI is one of the most indiscriminate crimes. Anyone can be your victim. And I'm sorry that your sons are victims, but we didn't make them the victim. We're not the ones responsible for them being victims. And so my vote today is to deny.
Mr. Tillett?
Mr. Smith, I also concur with Ms. Ledoux. I think you need to, what got me was 5 years ago, you had a problem reoccur. And I think with some more time and classes, that maybe the next time you show up, it might be a lot better for you.
I think it would be, yes.
So, Mr. Smith, what that means is on a 2-to-1 vote, you've been denied your parole request today. However, we're going to be watching you closely until your next hearing, which you can apply for. And we're expecting to see that there's no more contraband violations and no other violations, period. And some more classes done.
You have an opportunity now. You have what you would consider a setback. And now you have an opportunity to determine within yourself that you're going to move forward. Okay?
Yes, ma'am. Stay in the course.
And don't let the vote negate any of your good work that you've done. You've done some good work. You just need to do it for a longer period of time.
Yes,
This
sir.
will conclude our business today with Mr. Smith at 9:47 a.m.
Denied.
So please, I encourage you to let me know if you see it differently in the chat, but I don't see personally where he has put in a lot of work, at least not with regards to changing his mindset. Yes, he's done things like he's, teaching these welding classes and giving people skills and whatnot. That's great. But again, I go back to what got me is when they ask him if he's an alcoholic, he struggles to say yes. That's somebody who is, I'm sorry, until you can accept what you are and what you have to overcome every single day, you're not going to make it. So I think he's good just right where he is. If you see it different, like I said, let me know in the chat. I'm always open to debate or people telling me that I'm wrong. But that's how I see it. Anywho, back to Judge Boyd. She's no longer muted.
Let me read this.
Oh, sorry.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right. The court will find you guilty. The court will sentence you to 93 days in the Bear County Jail on 1244. Give you credit for any time served. There's to be restitution, and Deputy Lawyer.
That was Judge hitting her mute button. Let's see if we can move past it. All right. Well, we missed the end of that hearing. Let's see what she's got coming up next, I guess. Because it seems like she's unmuted now.
Yes, ma'am. And speak up loud so she can hear you.
All right, the court is calling 2024 CR 2336 State versus Larietta Holmes. Could I have parties announced?
Megan Galloway for state.
Charles Bunk for Ms. Holmes.
And are you Ms. Holmes?
Yes, ma'am. Yes.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Larietta Nicole Holmes who was placed on deferred adjudication in 2024 CR 2334 for the offense of injury to the elderly bodily injury on June 13, 2024 for a period of 2 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 39 in Bear County, Texas. The defendant, Larietta Nicole Holmes, did then and there fail to attend and provide verification of sober support / alcohol anonymous / narcotic anonymous meetings for the month of April 2026 and violation of condition number.
How do you plead to that? True or not true?
You waiving the ban on their meeting. Sure.
Any objections to the waiver?
No, Judge.
Did you understand by pleading true to violation of condition number 39, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in the prison and up to $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 39?
Yes, ma'am.
Court will find violation of condition number 39 true. Is there a proposed agreement?
Yes, Your Honor, the agreement for the court's consideration is that the court deny the state's motion, extend the defendant's supervision an additional 6 months. Place her on the intensive supervision ISP tracked order that she attend intensive outpatient treatment bi-weekly urinalysis for 60 days and the proof of enrollment in her school program.
All right. Is that the proposed agreement?
Yes, Judge, and her probation officer already has her school paperwork, so that part has been provided.
And do you all have any objections to the court reviewing the court summary?
No.
Thank you. All right, so here's the thing. I don't know if you're ever going to be able to successfully complete this probation. You keep coming back and it's always something else and some reason why you can't complete this and some reason why you're not doing what you're supposed to be doing. So I'm going to give you a choice. These are your only two choices. Number one, I'll revoke you. I'll sentence you to 2 years in the prison. Or I'll continue you, and I'll follow the recommendation. Which do you prefer?
So you and I follow the recommendations.
All right, so why are you not doing what you're supposed to be doing? Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
You can lower your hand and state your name for the record.
All
All right, why are you not doing what you're supposed to be doing?
Well, I did go do the 4 of the SOB classes. My probation officer was going to give me a bus pass so I can continue going to the classes. But on the 6th, when she had me do the last UA, she didn't give me any information about it. She had
Okay, let me ask you this. Are you able to go to the grocery store?
sometimes
All right, so here's my thing. If it's important to you, you treat it like it's important. Probation is not obligated to give people bus passes. So are you telling me if you don't receive a bus pass, then hey, I just can't do this, I'm not gonna do this?
No, I'm not saying that if I don't receive it, I just can't do it.
Oh, walk.
Yeah, that's a long walk, and I have no problem doing it.
No, I know it's a long walk. There are children in different countries. I was just watching a documentary. They walk 5 miles to school every day. And I'm coming to you as a person who, and your attorney. Guess what? You know the distance in 100-degree heat in San Antonio from here to the Bexar County Jail, wearing a business suit and heels? Guess what? I did that. I didn't have a vehicle. Nobody was giving me a bus pass. I figured it out. And you are in a precarious position because you're looking at 10 years in prison. And your whole thing is, well, I didn't get a bus pass, but we find ways to do other things. We find ways to get extra piercings because every time I see you, there's a different piercing. We find ways to get our nails done, but we can't do the conditions. So I will follow your agreement because this is what's recommended by probation, and the state is following the recommendation, and they've negotiated with your counsel for this. So court will deny alternate amend conditions to include 6 months extension. And if you would have done everything, you would have been done with this probation this month.
Tomorrow.
Yeah. And because you haven't, you're still on paper. IOP and ISP, there's to be bi-weekly UAs for 60 days. And she's already provided proof of school, is that correct?
But I've been told, yes, Judge. So we'll provide it again.
All right, that needs to be, proof of school needs provided. And Norma, set this for an update. Paul, so you're gonna be here the second week in July?
Yes.
All right, set this for a status, second week in July, please.
Yes.
Oh, this, like the 7th, 8th, 9th? No, the week after.
Yes.
13th is, no, I get back on the 14th. 16th is fine.
All right, we're gonna come
Nope.
back.
I'm at MD
Oh, no, no,
I'm out of town
no,
the 16th.
Okay, which date?
15th, Wednesday.
Oh, we can do it that, or we can do it towards the end of July.
30th is fine.
All right, so we'll put it for July
you, Judge.
30th. Sure. So you're gonna come back here on July 30th, and on July 30th, you had better have started on all of this and completed this. And if you need to bring with you proof of your school enrollment, just in case they say, hey, we haven't received it, because sometimes there are different probation officers, and you had better bring to me sober support meetings. Do you understand?
Yes, ma'am.
And so between here and now, I'm going to ask for sober support meetings 1 time per week. So you bring proof of that to me. And with the sober support meetings, they are all over the city. You can do them anywhere.
Plus
Do you
from
understand?
downtown.
All right. Is there anything else, something else you need from the court? All right. Thank you.
Okie dokie, friends. So, question that was popped up in the chat about when somebody can go in front of the parole board. And by the way, we're going to go back to the parole board and finish our day there in just a minute. Shake also asked, when can the fellow who got denied go back to the parole board? He can go back in 2 years. But so Louisiana changed some things. Major change in 2024. Offenses committed on or after August 1st, 2024, Louisiana has largely eliminated discretionary parole for adults. Most people in this category must serve their full sentence, or at least 85% with good time. Limited exceptions exist. For offenses before August 1, 2024, there's a formula. Most first-time nonviolent offenders and non-sex offenders are eligible after serving 25% of their sentence. First-time violent crime eligible after 65%. Second conviction for violent crime eligible after 75%. Third or subsequent conviction generally ineligible for parole. There are some exceptions, and I think one of the exceptions applies to the gentleman that we saw earlier. Specifically there, a sentence of 30 or more years, you are eligible after serving 20 if you've reached the age of 45. I think that's why he has such a long sentence, and he was able to get in front of the parole board after just 20 years. It has to do with his age. Certain life sentences can actually become eligible after 15 years. And then if you are age 60 plus with a clean disciplinary record, no major write-ups for the last 36 months, you've completed programming and you have a low-risk assessment, you can become eligible for parole after 10 years served. So long story short, there's a lot of different rules that go into it, depending on your situation. And it seems like if you were sentenced after August 1st of 2024, kiss your rear end goodbye, because you're going to be there for the duration. Okie dokie, let's go back to the board one more time. We will finish our day there.
The Committee on Parole is called to order. Today's date is June 11th, 2026. My name is Danny Barra, serving as your chairman today. My colleagues on today's panel are Mr. Tillis to my left, Ms. Ledoux to my right. We're in headquarters in Baton Rouge, and our remote location is still at Raymond LaBorde Correctional Center. We're here to do a hearing for Mr. Johnson. Mr. Johnson, would you please introduce yourself with your full name and DOC number for the record?
Yes, sir. My name is Christopher Johnson, DOC number 472377.
All right. I'm going to give you a brief explanation of the process. We're going to read some information, ask you to verify it. We're going to give you a chance to speak and tell us what you did and what caused your incarceration and why you should be released. Then we're going to ask the warden some questions. We'll allow public input, and we'll conduct a parole interview. So let's begin. Today we have for parole consideration Christopher Johnson, DOC number 472377, who's a first felony offender who's been convicted of forcible rape, reduced from aggravated rape, and on August 18, 2003, was sentenced to serve 40 years hard labor, with the first 15 with no benefit of probation, parole, or suspension of sentence in Caddo Parish. Your parole eligibility date is December 28th of 26. No good time date available. And your full term date is 12/28/41. Does that sound correct to you, Mr. Johnson?
Yes, sir.
All right. Go ahead and tell us, what do you do to cause yourself to get incarcerated, and what have you done since then that we would want to make us want to release you early?
But first of all, I want to thank the board for giving me this opportunity to express myself. The day of the incident was August the 3rd. You know, I was initially supposed to go get a video game from my friend. And I went over there, I stayed over to my friend's house for a little while, and I was playing the game and stuff like that. And the victim that was involved, which is JH, when they asked to go outside, and they didn't have nobody to go outside with them. So now initially I already had this paper. It was like a pornographic picture. You know, I was a kid, like it was a pornographic picture. And I went outside like that while they outside playing. I really tried to like, I would say I tried to go sneak and like relieve myself, because at the time, like I wasn't like sexually active at all. I'm just being honest. And the victim walked in on me like masturbating. And I tried to send the victim back outside, and the victim had said like they were familiar with what I was doing. So I kept fussing like, go back outside, go back outside. So what I did, I thought the victim went outside, but came back in there and caught me like naked. Now I could have made the decision to actually like wait, being somewhere where it's privacy. But I didn't wait. So like I end up taking my clothes off, which I just had on some basketball shorts at the time anyway. And the victim was there, and I didn't never have the intentions. Like, I don't even know what was running through my mind at the time. Like, and all I did, like, I had this picture that I was looking at, and the victim was there, and the victim got naked as well. So what I did, like, I just masturbated. All I did was masturbated, and that's how my semen ended up on the victim. And when I left, I wasn't even thinking about it. Like, I just had left. I wasn't thinking about it. So they came to my house, and when they was explaining it to me, and like they showed me the semen and stuff like that, and I was like, man, I wasn't even thinking about that. So that's how the situation happened. It wasn't no more than probably like, the incident wasn't no more than like probably like 3 to 4 minutes at the most. But I actually felt bad about the entire situation. It's not because I got caught, because that particular day I could have made a better decision. And I knew that I'm a better person than that, but I just wasn't thinking. Like, I was a juvenile. I wasn't thinking about the damage that I caused nobody. I wasn't thinking about the families that was involved who actually loved me and treated me as a relative as well. So throughout this whole ordeal, I always felt a great remorse to where if I can go back to that day, if I can give my life to go back to that day, and that can restore useful life and useful health to the victim, that's something I do in a heartbeat. Like, to go back to that moment, if that'll take my life for them to sustain and thrive in society, knowing that this shouldn't have never happened to them. But
Mr. Johnson.
Yes, sir.
The report I have doesn't read the way you're saying it. Did you strike the young child?
You want me to be honest?
I'd like for you to tell me the truth.
The honest truth is I did it.
You struck him. And you said that, his mother said that you asked her, could you play games with him? And what got me was, you were 16.
Yes, sir.
And he was a 6-year-old child. So please be truthful with us.
Honestly, yes, I struck him.
And you forced him to have sex?
Yes, sir.
Okay. You want to go with the warden? They want me to continue? Well, he never told us yet. What are you going to make us know? Okay, tell us why you feel that we should allow you to be released.
Because of the transformation that I've done throughout my incarceration.
What kind of classes have you been taking?
I've achieved risk management class, anger management. I completed my said diploma. I got NSC on forklift operating classes. CPR.
I saw those. Did you have any sexual abuse classes?
Yes, sir.
You did? Which ones?
Risk management. It has 27 factors to it, risk management.
Okay.
As well as victim impact also.
Which one of those classes that you've been taking impact you the most?
Victim impact.
Victim, tell me about it.
What I love about victim impact, it shows you that your actions, how it can affect not only you, but all the parties involved from your family to your community as well. And what I learned about that, what I didn't understand as a kid, like one decision can alter your whole entire life if you don't safeguard your thought process. And that's something that I had to grow over the years to really learn. And victim impact established that within me to where the way I look at life now, everything that I do, I say to myself, Chris, think about who it's going to affect. I left people out there to where I did serve the public, but I wasn't aware of it. And victim impact showed me how me coming to jail, I neglected elders that I helped out there as well in society. Where if I walk them to the bus stop to make sure they don't experience purse snatching or they don't experience no form of crime because I have a grandmother. So I was wondering like who protect her when she walked to the bus stop if I was there to do it. Like who took her trash out in the morning where she thought she missed the trash man and I was there to do it. And I come from school and my neighbors thanking me for stuff like that. So I always felt good to be able to serve the public. I just made a mistake as a kid where I wasn't thinking because I know that I'm better than that. And all the things that I've achieved in jail, I'm proud of it. Because I never experienced a lot of things out there in society that I experienced in jail. The mental psychological torment that I went through, not only that, the mental growth that I experienced. So
Horton, what kind of guy is this guy? What's your comments on him?
Okay, well, he's had 14 total write-ups since he's been incarcerated. 9 of those have been sex offenses, aggravated sex offenses. And 7 of those were after he took risk management phase 1 through 4 in 2006. The last one was in 2021, I'm sorry. So that's what his disciplinary looks like. I think that he needs to take sex offender treatment again, as well as enroll in our sexual idolatry class that we offer here.
Good. Is it a problem getting him in there?
No, sir, it's not.
He hasn't applied for it himself?
He has not.
Okay. Thank you, Horton. We appreciate the work you guys do.
Along that vein, I will note that his static 99 score, which is a risk assessment tool for sexual behavior, is a 3, which is high, in my opinion.
All right. Today we have in support Sophie Reese from the First 72 on Zoom. Can we hear from Sophie?
Hello, yes, and thank you to the board for the opportunity to speak on behalf of Mr. Christopher Johnson. He reached out to our office a few months ago, and we've been in communication ever since about his plans for reentry. He's determined that the most supportive reentry plan would be in Shreveport. However, we still wanted to come on the Zoom and express our support for him. He has noted in our meetings with him that he's determined to be around positive people and that he understands that he would need to take it one step at a time upon his release. And he has a constellation of support both in New Orleans and in greater Louisiana. And so if he were to come to New Orleans, we would be happy to support him, to provide him with peer support, reentry case management, classes, job coaching, financial coaching, and all of the resources that we offer. And he just has expressed to us, like, and also through his classes that he's taken, that he is a hard worker and that he's determined to be successful upon his release, and that he's been very proactive in that process in terms of reaching out to us. I've also been in communication with the Muslim Reentry Initiative in New Orleans, who he's also reached out to and who are eager to work with him as well. Thank you for your time and consideration.
Are y'all offering him housing?
No, so we're unable to offer him housing due to his charges, which is why it was determined that Shreveport would be the best reentry plan for him.
All right, thank you. All right, we also have Terrence Wynn, a friend who would like to speak.
Hello, and thank you for this opportunity to speak on behalf of Chris. I've been knowing Chris ever since he got off the bus and came to prison, and he was always a young person that was trying to better himself, trying to right his wrongs. He's always expressed his sincere apology about his actions that brought him to prison as a kid. My organization, Pipes, we're offering all the support he needs. We have housing for him, we have employment for him, we have a peer support group to help him through whatever hard times he would have. But we have housing and employment for him. So in any way we can help him, we're gonna help him if the board gives him an opportunity to be released today. Thank you.
Thank you. We also have in support Kokima Johnson, cousin. You hear from Kokima? Go ahead.
Thank you for giving me an opportunity to speak on behalf of Christopher. I'd like to thank you guys for taking that time. Growing up with Chris, understanding the hard times that he went through as a kid, and just before the incident at hand that took place, seeing what Chris was trying to do. I was the one that was in his life trying to help him make some better decisions. I myself, just a few years older, feel like I failed in that respect. But knowing Chris, having the conversations that we've had, he had just recently joined a program. He was actually in a program when he was arrested to try to better himself and try to somewhat go into the Marines. Unfortunately, that didn't take place. I know the remorse that he's shown and we've talked through over the years. I like the board to know that he has support out here, both mentally and financially as well. We're here to support him, not only just through getting through housing, but also getting any type of counseling and things like that that is needed. We do know that it'll be an additional transition coming from going in as a kid and spending over 2/3 of his life, or close to 2/3 of his life behind bars. I ask that you grant him grace. I do know that he had some incidents inside, but that was a child trying to grow up in an environment that's not conducive to anyone. But we, as his family, is here to help him get to that, and we want to see him home with us. We also want to see him be a great part of the community moving forward. Thank you for your time.
Thank you. We also have support from Essex Johnson, a sister who's on Zoom but not speaking. We also have attorney Richard Spears, who's representing Mr. Johnson and will be speaking. Go ahead, Mr. Spears.
Good morning, and thank you for the opportunity. Ladies and gentlemen, I've been representing Mr. Johnson for a while. I looked into the legality of his juvenile situation and the conviction. And over that time, over maybe 7, 8 years, I've gotten to know Chris. I will say before I start about legal stuff, on the personal level, when I first met Mr. Johnson a number of years ago, although he was an adult, he was still kind of mentally a child. And a few years ago, he made some kind of a switch. And we use the word remorse, but I'll add another word to what my observation of him is, and that is shame. And so when I was watching him talk earlier this morning, I just wanted to say, having spoken to him and gotten the truth out of him myself, he is not minimizing for the reason that most inmates do. If he did that, it's because he does have a sense of shame about this. And shame is something we don't talk about much, but I know that it weighs heavily on him. Having said that, I know that he, and I don't want to belabor what everyone else has said. He has a large family. I get calls from lots of family members with questions about his situation. He has an elderly grandmother who I understand part of his plan is that he's going to take care of her or help to take care of her. Mr. Johnson, Mr. Kokima Johnson, who just testified, has been heavily involved and been in contact with me about what can be done. There's no question that he was 16, he was a juvenile, and from what I gather, he was very immature even for 16 when all of this happened. And he's been involved in some other instances, but at some point he turned a corner, and I find that he does have remorse. His sense of shame and what he has learned and the punishment that he's endured at his young age has put him in a situation where I do not believe that he will reoffend. I won't lay out the law. I know that you all know the law about parole standards and so on and so forth. I too ask that you consider all of those factors that I just talked about and what everybody's talked about, and giving him an opportunity here.
Thank you, Mr. Spear. Appreciate you. All right. In opposition, we have the victim's grandmother, who's opposed to early release. We also have unanimous opposition from law enforcement. The judge is opposed, the DA is opposed, the sheriff's opposed, the chief of police is opposed, and the attorney general is opposed. So we do have opposition. Mr. Tillis, do you have any more questions?
No. Mr. do you have any questions?
I don't have any questions. Thank you.
And I have no questions. So it would be time to vote. Mr. Tillis, the case is assigned to you.
Mr. Johnson, after reading the case and then talking to you this morning and seeing that you admitted to what you've done, I appreciate that. Also, I realized that you were young when this happened. And all those when you were young would do some crazy stuff. But you've been incarcerated for a very long time and you still haven't changed some of your bad habits. I believe and I hope that you will continue moving forward. Today, my vote's going to be to deny, and I hope that you get some more classes, as the warden says, and you need to go ahead and sign up for those. And perhaps when you come up for us again, that I think it would be different. But you've got strong family support, but you've got to do what's right. You can't just come in here and talk a story. You've had 7 write-ups and they weren't the best write-ups in the world, but go ahead, say what you want to say.
I just wanted to say that, like, I went through a lot of transformation and I've changed a lot. But what I noticed wasn't mentioned. It wasn't mentioned that, like, if you look at my record, look at the times I had write-ups and the times I went without it. Like, for instance, I went like almost 5 years without a write-up. So I just stopped. My actions just stopped. Because it wasn't about the board, it was about me bettering myself, like preparing for society. I tuck my shirts in, I walk on the side of the yellow line, because I want to have a structured life that consists of obedience.
I believe that, and I hope you prove me that you have. I think if you get some more classes and continue on a path that you've been 5 years without a write-up, I'd like to see you with not any more write-ups. But at this time, my vote is going to be to deny. And I'm sorry, and I hope you do better. Actually do.
Mr. Johnson, no one is negating the work that you've done while you've been in prison. However, there's some other things you need to do. Today, my vote is to deny. You can allow this vote to put you back, set you back. The warden knows that that's the potential that happens when we deny someone, but you can also take this opportunity to move forward. You have the opportunity to write back. I need to see a sustained period without sexual write-ups in your jacket. Votes to deny.
Mr. Johnson, I also vote to deny based on the violent crime against a 6-year-old victim, the unanimous law enforcement opposition, and the victim's family opposition. I highly recommend, like the rest of the panel, that you take the additional sex offender specific classes that are offered and that you remain write-up free before you submit your name back for another hearing. Good luck to you. Today, your parole request has been denied, and this would conclude our business with Mr. Johnson at 10:22 a.m.
Denied. I would like to point out, friends, that had he been sentenced after August 1st, 2024, he would not even be eligible for parole. He would have to serve the entire time. If only we could bend time. I can't tell you the last time I've seen somebody in front of the board who just doesn't seem to get it to that level. But I don't know. I might watch that one back at some point just to fully wrap my brain around what was trying to be argued there, because I don't get it. Anyways, that concludes today's show. I hope you all enjoyed it. I know I did. We'll be back tonight for Sidebar, 8 p.m. Eastern, 5 p.m. Pacific. We're going to dig into yesterday's Horton hearing and maybe dig into what exactly is it going on with Judge McNally that he keeps giving this guy infinite chances. So that's what we'll talk about tonight. We'll be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific for Super Friday. And if you're a channel member, join me a half an hour earlier, because I think Lindsay is going to have blotter tomorrow morning. So definitely want to check in for that. Today's wisdom, one of my favorite quotes ever, David Foster Wallace: "The truth will set you free, but only after it's had its way with you first." Chew on those words. I think they apply to everybody, but they certainly apply to the things that we see here. Go have yourselves a great day, everybody. We'll see you in a few hours. Take care. God bless.